with
All right.
a felony.
All right. Well, anyways, this was supposed to be a recommendation for the prosecutor, and it isn't necessarily a sentencing agreement, but apparently that's not what you request. Is that correct? You can change your mind between now and sentencing, I guess, if you choose.
Yeah.
All right.
Yeah.
All right.
Yes, sir. I'm sorry.
It's okay.
I'm kind of confused with everything that you
Well,
said. So
that's why you've got Mr. Champion there. He will unconfuse you. Mostly.
Or make it worse.
No, he'll do fine. All right. So far, Mr. Denhoughton, did I get the plea agreement right?
You did your.
Mr. Champion, other than that little hiccup?
That is the correct statement. I'm thinking right now.
So, Mr. McKenzie, now I have here this pre-trial agreement. I'm going to hold it up for you. And it's 2 pages long. The terms really appear only on page 1. And on the back, on page 2, is some signatures. I'm looking right here. Is that your signature?
yes, sir.
Okay, well, you should shrugged your shoulder. Did you sign a piece of paper?
I did this
Okay.
morning. Yes, sir. I did.
Good. Now, before you place your signature on there, did you have the opportunity to go over and speak with, the evidence, your rights, your
Yes.
choices with Mr. Champion?
Yes, I did.
And he made himself available to you?
Yes.
Did he answer all your questions in a way that you understood them?
Yes,
All right, good. And so therefore, are you satisfied with his advice at this time?
I am.
All right, good. Now, also, if you enter this plea today, as I described, and I accept that plea, you'll be waiving certain rights and not have a trial. Does that make sense?
Yes, sir.
All right. So the second piece of paper I'm holding up is one that says advice and rights. And again, looks like your signature. Is that your signature on this document?
Yes, sir. It is.
Now, before you placed your signature on there, did you read through all these terms and conditions?
Yes, sir. I did.
And this one, I don't mean to sound insulting. Did you understand all of that? The words?
Yes, sir.
Okay, so you understand that you are waiving all these rights that are listed on this page?
Yes, sir. I do.
All right, thank you very much. Also, you're going to be giving up the right to claim later on that this plea was a result of some promise, threat, or inducement not told to me today. So, before I get ready to take the plea, have there been any other promises, threats, inducements, coercion to force you to plead guilty?
No, sir.
Are you doing so then? Hold on. You're jumping my gun, man. I get paid in my words. Just take a moment. Are you making this plea of your own free choice?
Yes, sir.
Great, thank you. Now, there's this thing on page 1 of that pretrial agreement. It talks about sentencing, and it has this thing called the Michigan Sentencing Guidelines. Now, those guidelines are used for felony cases and felony convictions, and they are given to the courts by the legislature. Now, we are not required to follow them. We take them and we are required to consider them, but we don't need to follow them. And what they do is they establish the minimum end of a sentence. So I told you, for instance, this as it's a felony punishable by up to 5 years. Now, the attorneys appear to think that they estimate the guidelines would suggest a sentence of 0 to 3 months. All right. Now, I want to highlight for you, that's not binding on me. Next, it says the word estimated, which means they could be right, they could be wrong. Do you understand?
Yes.
Good job. All right, thank you. Has anyone made any promises to you or asserted, hey, this is exactly what Judge Elmore is going to do for sentencing?
No, sir.
Good. I don't know. All right. But I'm going to guess the priors must be quite old. Yeah. All right. 10 years. Well, anyways, knowing all that, Mr. McKenzie, do you still wish to enter this plea of guilty that we talked about today?
It is, sir.
All right. Thank you. As to count 1, operating a vehicle while intoxicated, how do you plead?
Guilty, yours, sir.
So I'm going to ask you some questions. I've got to be able to make sure that you actually believe you are guilty. So turning your attention to April 17th of this year, over in Lake Township in Missaukee County, were you operating a vehicle on a public roadway?
I was.
Looks like it was somewhere either on, looks like it was on West Jennings Road near South Blythe. Is that right?
Yes, sir.
And at that time, did you get pulled over by a police officer?
I did, sir.
And had you been consuming alcohol?
I had.
And Mr. Denhout, do we have an intoxilizer or breath?
It was a lab report.
Go ahead.
It was a lab report, Your Honor. The results were 0.228 blood alcohol content.
Mr. Champion, does the defense so stipulate?
We do, Your Honor.
All right, thank you. Now, Mr. McKenzie, is it also true that December 12th, 1997, in the 84th District Court, which I presume was either here or over in Wexford, you were convicted of operating while intoxicated? Is that right? Did you have a prior conviction in 1997?
Yes, sir.
Okay, sure?
Yeah.
All right. And is it also true that you had another operating while intoxicated conviction on May 2nd of 2016? And that looks like it was also either in this court or this court over in Lakes or Wexford County.
Yes, sir.
All right, thank you. Mr. Denham, do you believe the defendant provided a factual basis to support the plea?
Yes, sir.
Are you aware of any other promises, threats, or inducements?
No, Your Honor.
Do you believe the court's compliance with Rule 6.302?
Yes, sir.
Mr. Campion, do you agree with all that?
I do, Your Honor.
Thank you. The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the required elements for proof. Therefore, the defendant is found guilty of count 1. Count 2 and 3 will be dismissed at the time of sentencing. Sentencings, Mr. McKenzie, are generally done in about a month after taking the plea. Sometimes it can be up to 5 weeks. Between now and then, an agent from the Michigan Department of Corrections must prepare a pre-sentence investigation report. This report is prepared anytime someone is convicted of a felony in a state court in Michigan. That report will come to the judge and come to the attorneys, and it will tell us, here's what the charges were, here's what the plea was, information about the defendant's prior criminal history, performances on bond, performance on probation, other facts about that you're going to provide an answer, like about work history, things like that. It will also include a scoring of the Michigan sentencing guidelines. And I talked to you about that earlier when I pointed to on that pretrial agreement on page 1. Again, the guidelines are not mandatory, but they are an important tool for the courts to consider. Next, it will also make a recommendation as to sentencing. That is merely a recommendation. It's strictly up to me. All right. Now, there are 3 steps that involve you, sir, in the preparation of this report. Number 1, when you leave this courtroom, that person over there is going to give you a packet and going to schedule an interview with you. You're going to fill out that packet, turn it back in, and they will schedule an interview with you, for you with one of their agents. Then that agent will prepare the report, and when it's done, which is generally about 2 weeks or 10 days prior to sentencing, the attorneys will get it, I'll get it, and Mr. Champion will have to sit down and go over it with you to make sure that whether or not there needs to be any corrections. Sometimes they might get information incorrect, so we need to make sure that it's complete and accurate before the court uses it to help establish a sentence. Do you understand today, Mr. McKenzie?
Yes, sir.
Do you have any questions about this process for me at all?
No, sir.
Okay, good. Now, you must have some bond conditions, right? Are you doing breath tests? Or,
Yeah, I have a,
Yep, soberly?
yes, sir.
Good. So, and did you go to community corrections? Because we don't do those.
Yes, I am.
Great. Good. Good. Well, make sure you can continue to be compliant with those terms or conditions. How you perform on your bond is a big issue for this court. It tells me whether or not, well, probation is going to work or probation may not work. All right. And you probably want it to work.
He's doing well, Your Honor.
I'm very happy. And if you need any other assistance, there's nothing wrong with going to that community corrections office and saying, you know what, I could use some outpatient therapy just to help me get through whatever. There's nothing wrong. That does not work against you. It works for you. All right. So if you think you need any outpatient treatment, you can either get it on your own or go to Alex at that office and she'll help get you into it. Okay. All right.
Okay, that's good to know. Thank you, sir.
You're welcome. Anything else, Mr. Denham?
I would just indicate that I'm not aware of any bond violations, so I have no objection to continuing bond.
Bond hereby continues. Anything else, Mr. Champion?
Yeah, thank you.
All right, great. Thank you. We are
Here.
Thank you. All right. Our next case is People of the State of Michigan versus Joshua Meathoff. Did he just walk out? He did. Hartel. All right, so this is case number 26-3659FH. Is this Mr. Meekoff?
It is.
Yeah, sit next to him. All right, thank you. He doesn't bite
Yeah.
hard. All right, appearances, Mr. Denham, did I get yours already?
Not yet, you're right. Thank you, David, and on behalf of the people, Your Honor. Thank you.
Robert Hartzell for Mr. Meekoff, who joined me on the left, Your Honor.
Right, you may be seated. All right, we're here today for sentencing in this case. It involves conviction for 2 and operating while intoxicated is a third offense, and possession of a firearm while under the influence. It was resolved with a couple pleas of no contest back on May 8th. One moment. Yeah, there we go. I knew I had something else. So review these earlier. All right, so also before we get to the pre-sentence investigation report, this court received last, I think it was Wednesday or Tuesday, a Catholic Human Services report on Mr. Meekoff talking about or giving me an alcohol and substance use assessment. I read through that, made some notes and things like that. So I covered that last week, and also received by my office on that same day was a mitigation report for Mr. Meekoff. And normally I make notes, so give me just a moment. Oh yeah, that because the Sarah Lee Bakery. All right, now I remember. And then attached to that were several letters. We have one from Dr. Deere, who is at the Lakeshore Community Counseling Center. Talking about its progress there. And there were some other statements or letters here that I received. Okay. And it looks like he's done a pretty consistent job here with attending AA classes. All right, let's turn right back here to the pre-sentence investigation report. Mr. Denham, do people have any amendments, corrections, objections to make to the contents of that report?
Thank you, Your Honor. I have reviewed that report thoroughly, and I have no proposed corrections, additions, or deletions.
Okay, thank you. Mr. Hartel, same question, sir.
Yes, Your Honor. We asked the court to consider on CFJ 145 under the term of the probation, term 4.20, amending that just to no firearms. I do believe it would be appropriate. That way my client could still go bow hunting, things of that nature. We're not sure how much probation the court's going to give him, but I don't believe there are any allegations in the report of any bows being misplaced, anything. I do realize there were other issues the court may take issue with.
Which you said 4.20?
I believe
Yep.
that's the condition where it mentions no weapons, Your Honor.
Yeah, all right.
I know the court sometimes has given that grace. I'd ask the court to consider it in this situation. Thank you.
Thank you. That's really more for allocution and mitigation. Mr. Denham, do you have any comment on that?
On that particular condition, I would simply leave it to discretion.
Copy that. Thank you. All right. Let me take a quick look. Anything else, Mr. Hartel, as to the contents of the report?
No, Your Honor.
All right. Thank you. I'll just note here, I did go through obviously the CFJ 3-4 section. There were a couple of charges or cases for which he had some dismissals. Clearly, the court does not take those into consideration. And I don't think I had any other corrections here to make. All right, allocution. I'll start with Mr. Denham.
Sure. Thank you, Your Honor. First, the people, I guess I'll start out positive. I'm not aware of bond violations, any bond violations. So I'll give credit to the defendant for that. I think that he's been performing well on bond. However, the defendant did receive a significant benefit of the plea agreement. We did dismiss the felony firearm count. I support the recommendation. The incident itself involved allegations, being on the lookout call. Allegedly, the defendant was all over the roadway. Ultimately, he was found as a local Wesco. He was somewhat non-compliant. When the blood draw was done, which was approximately 2 hours after the incident, so a significant period of time had elapsed, he still had a blood alcohol content of 0.239, which is, as the court is aware, about 3 times over the legal limit. So significant.
Steve, I think we need to learn from the challenge.
Hold on just a minute. Go ahead, Mr. Young.
Okay, so significantly over the legal limit. There was a loaded gun in the vehicle. There were vodka bottles, at least 2. The PSI report notes that there's been a series of drinking and driving convictions in a relatively short span in the last few years. The defendant, I guess, reached my radar and of some concern on the 2024 incident, the failure to report an accident. That involved the defendant running into the backside of a manure spreader that was going 33 miles per hour at the time. He went into the ditch, went through the windshield. Witnesses indicated that blood was coming from his nose, and he was picked up from someone. So that raised some concerns for the people, given that scenario. He was not at the scene, so he was not charged. I'll leave it at leaving the scene of an accident. But certainly that raised some additional concerns separate and apart from the OWI convictions. I do support the recommendation, Your Honor. I would respectfully request the court follow the recommendation of the probation department.
Mr. Hartel, did we miss something? Did there need to be a change?
Not that needs to be changed, Your Honor. My client may or may not wish to make a statement after my elocution. That's what he was informed.
Oh, okay, no problem. All right, thank you. Mr. Hartel, floor is yours.
Thank you, Your Honor. We also recognize that my client received a significant benefit from this plea. We realized there was an absolute minimum sentence as it was charged that would have sent him to prison. We're very glad that's not happening. He's cognizant of that fact here today. He is employed, as the court did note, at Sara Lee Factory. He reminded me earlier this morning, his shift is from 2 a.m. to 2 p.m. Quite the fun shift. I've done a few of those myself at different locations where things close to them, maybe graveyard shifts is my point. We would ask the court to fashion a sentence where he could maintain that employment and do the jail sentence on the weekends. We realize there's a minimum 30 days here, and the court can go about that. But I know sometimes the court does allow, with its grace, to allow my clients to do 48-hour chunks on the weekends. And even though I've informed him you most likely would want a GPS tether on him as you've done in the past, he would be willing to comply with that. He very much so wants to keep this job. He's informed me he has the support of his coworkers. He wants to continue to show them that he can be a good colleague, have his job so that he has good support structure when he gets done with the term of probation that we don't doubt, Your Honor, will give him probation as well. He also continues to have the support of his family. I know some friends and family wrote letters. Others, I'm informed, still support him, but just didn't quite get the pen to the paper, but are definitely still there. They may or may not be watching right now, in fact. I would also ask the court to consider allowing him a week before starting any jail sentence so that he could tell his employer exactly what's going on. He was honest with them, he tells me, but because he didn't know exactly what the sentence would be, he obviously wasn't able to communicate that. So if the court give him a little bit of grace before the first day in jail, we'd appreciate that as well. As was noted a moment ago, he may or may not wish to make a statement. That's at his discretion. I've given him my advice on which things may or may not be the best to say. I realize this was a no contest, so I won't overly allocute. I know the court has to take everything in the report as accurate, but because it was more for lack of recollection than civil liability, if he suddenly had better recollection, I just ask the court to factor that in. Thank you.
All right. Mr. Meekoff, you have the right to make a statement if you so choose.
I guess all I've got to say is that night was 35-mile-an-hour winds. It was windy. I hadn't drank until I was at the parking lot waiting for my ride to pick me up. Vehicle was off, and the person picking me up did speak to the cop on the phone when he approached me. I was on the phone with them. I guess that's about it. Again, if I could somehow maintain my job, that'd be great. Or if not, I understand.
So, okay, I'm sorry, keep going.
I guess a week or so I could get my house arranged. That way I could let my landlord know that I'd be leaving the property or whatever.
Whose vehicle was this?
Well, it was my mother's.
How'd you get it?
I was working on it.
Okay. How do you get to and from work?
I get picked up, I carpool. That my mom will take me to work.
How is it that you remember this now and you didn't remember anything last time I took the plea 2 months ago?
I guess I didn't really quite understand everything.
What do you mean you didn't understand everything?
As in like the no contest or
I
whatnot.
explained it to you. I told you you couldn't challenge what was in the report.
Right.
How was that? No, how was that not clear?
I guess I just wasn't. I mean,
You weren't being honest with yourself or with the court, because I'm pretty clear when I do a no contest plea.
right.
And you told me you couldn't remember. Which means if you try to tell me you remember stuff, I think you're lying. So I don't know. There is no better way to explain it than I do. I'm pretty sure. I'm not patting myself on the back, but I say you cannot challenge what is said in here. And so I don't care if it was windy. You were obliteratedly drunk, swerving, putting people in danger. Whatever you've been telling yourself prior to sitting there in that chair today is wrong. Your hopes are not going to be met. You will be leaving through that door in about 4 minutes. You are not going to go to work and say, and give you another week. I don't know what the heck you've been doing in the last 2 months if you didn't tell them that that was a possibility. That does not matter. You are 31 and you have 3 drinking and drivings within 6 years. And in this instance, you were all over the road enough that people called police. You were driving when you could not drive a car. You were unlawful for you to drive a car. And it was unlawful for you to possess a firearm. Was that, am I right?
Loaded firearm, yeah.
Yeah. No. Yeah, I'm not going to let you go hunting. You can't possess a firearm. You can't possess a loaded firearm. And you were drunk with the blood alcohol level that would put most people in bed for a couple days, passed out. Oh, no. I really hope what you told me was the truth. And if your mom's out there watching and she says, thinks to herself, and she goes, well, I kind of let him have it, borrow it. It's her fault then that you got it. If she didn't, then that's not her fault. It's only your fault. So I don't want to be insulting to your mother, but I'll tell you, if somebody else was letting you drive their car, they were wrong. Had you killed somebody, it would have been on them too. Yeah. No. And I appreciate you've been going to AA. That's great. Because you need it. Now, I'm also looking here, and there's some issues here about, depression and anxiety. I don't see any medications of treatment because apparently you are treating everything with alcoholism. And you began using at a young age. Age 17, 3 to 4 times a week in the last 13, 14 years. Wow. You set yourself up for failure.
Yes, Your Honor.
So, and I'll tell you, I'll tell you why I talked about credibility, and that's what I jumped on right away when you started telling me about what you remember and then telling me I didn't do a good enough job explaining it to you. Well, you had a 3/4 empty bottle of Smirnoff in the car. But actually, there are 2 bottles. You lied to the cops about what you had been drinking. Failed 3 of 3 tests that were given to you. So again, 31 years of age, and your criminal history began about 15 years ago. Unlawful driving away of a motor vehicle and malicious damage of property. You were given a chance. Then you have this fail to stop at an auto accident. Then you have in 2019 an open intox of vehicle and violence charge, although there's only an open intox for a conviction. Then in 2020, sure enough, open intox and drinking and driving. 2022, open intox and drinking and driving. And then 2023, driving a vehicle while your license was suspended, denied, or revoked. I'm not going to ask, and I don't want you to answer because it ain't going to go well. Boy, I would like to know whose car that was. And then in 2023, which was while you were on probation for the last one, you picked up another driving license suspended, which means deception. You're going to do whatever you want when you think no one is looking. And then 2024, oh my gosh, failed to report an accident and driving license is suspended, denied, or revoked. Now that charge was dismissed, but if you fail to report an accident, it doesn't take much. It's a logical conclusion that you were driving while your license was suspended. And I would love to know whose vehicle you were driving those times. Who's ever allowing you to drive their vehicles? It's too bad on them. And now here you are in about a year, and you've got felony firearm, R&O, which I know those were dismissed, the possession while drunk, operating while your license is suspended, denied, or revoked, which I know that was dismissed, but obviously I could tell if you were drinking and driving, you were driving while your license was suspended. So I've got deception, alcohol, and violence wrapped all under one here. So, yeah, you might be a good employee, but boy, I would never let you walk into my place of business or work without giving you a breath test every single time. So I appreciate that you're getting the help here, and that's great. And I'm going to help. So at the age of 31, you realize your days of consuming alcohol are without a doubt gone. Because if you do it again and you get caught, your only next place to go is prison. And I would have no problem sending a 4th drinking and driver to prison.
Yes, Your Honor.
The court sentences the defendant as follows: 36 months of probation. You have the right to be considered for early release from that probation at halftime if you are successful with the terms and conditions of that probation. The court adopts every single one of the terms and conditions that are listed in CFJ 145, pages 2 and 3. I find that they're well suited for rehabilitative purposes. In this particular file, the court sentences the defendant to 12 months in the Missaukee County Jail, and he receives three days of credit. Court assesses a $68 state minimum fee for the felony, and there were two, and the other is a $50 state minimum fee for the misdemeanor, $130 crime victims' right fund fee, a $300 court cost, a $500 fine, and a $300 attorney fee for all the processing of this case from beginning to end. DNA fee was already available, apparently. Supervision fees are $30 a month or $60 a month if there's any electronic monitoring.
Sorry, I made mistakes.
So again, that's actually listed as 365 days.
Okay.
All right. Have I missed anything, Mr. Blazak?
I just wasn't sure if you were done with the second.
Oh, second, thank you. 93, I'm just going to go 90 days in jail with 33 days of credit. Those two sentences run concurrently with one another. All right. Thank you. Anything else, Mr. Blazak?
No, thank you.
Mr. Denham?
Nothing further on.
All right, Mr. Hartzell is going to bring you 2 copies of one document. You're going to place your initials on one copy. Doing so neither elects nor waives any rights. Based upon the plea, any appeal done in this case will be by filing an application for leave to appeal and not an automatic claim of appeal by right. Furthermore, if you wish to have the court appoint an attorney to assist you in an appeal, you may complete the bottom half of that document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. The number one thing you did wrong, the number one thing you tried to do today was try to tell me, oh yeah, now I remember, and I wasn't told well enough what was going on. I didn't understand. I don't believe you. Don't talk. You're going to make it worse. Just put your initial on that one page. The sentence is well within the guidelines. This is a straddle cell. The court could easily send the defendant to prison. And you're going to note one thing. Had I sent you to prison, you could have gotten boot camp. You probably could be out a lot faster than you will be when you're going that way. Thank you, Mr. Hartel. Keep blaming it on the wind.
My client has asked me to ask the court. I know the court. Okay.
Going to jail.
All right.
It's not on weekends. You're going to jail. Blaming it on the wind, that was a bad choice. Thank you. All right. Oh, you know, get those back information. Our next file today is People of the State of Michigan versus Jamie Sheppers. File.
So, and I will adjourn the evidentiary hearing to what, August 10th? August 10th at 11 a.m. And then the other issue is, young man, you have a warrant out of Wayne County on a probation violation. We've kind of talked this. We were talking about that and how to do it and try to get you there as quickly as we can. Let you deal with that. All right, you'll have enough time between today and then hopefully to get all of that resolved. So what I'm going to do, I'm going to take you into custody on that warrant. Okay. I'm going to adjust your bond. And I've talked to your attorney about this because you have a tether on, right? Okay. So I'm going to remove your tether. So you're not going to get that restriction. I'm going to set your bond at $1,000, 10%, so $100. You had indicated he had family here with him that could post. So that bond to be posted, but I want to make sure they can post because otherwise you'll get to Wayne County, you'll have that bond. And then if you resolve everything there, they're going to hold you. And I just want to make sure is that Dan? Okay. You can post that, the $100. Okay. So that'll all work. Hopefully, all these plans we lay out, try to make it seamless, probably won't work, but we'll give it our best shot. Okay. Sure. All right. So you go get that stuff straight in Wayne County. Okay. You'll go with my bailiff there.
Thank you very much.
All right. Thank you.
And the PCC is also set on the 10th, correct?
Yes, we'll set the piece
Motion
and everything, the motion here. All right. Thank you, folks. They filled out no papers. That's the whole day.
Oh,
I could have stayed in bed.
I concur.
All right. Well, I'm glad I did.
Number is 26-366 FH. Your appearance, I took them. I thought they were bringing him over. And
Who's right?
to the PSI.
The people do not.
Mr. Champion, the same.
Then, Your Honor, I was going to object to OV10, but in further research, it is scored appropriate.
All right, thank you very much.
Could not have doubted the probation.
It's okay. All right, thank you very much. Let's turn over to the people. Oh, wait, hold on. I will note that I went through the report and I did not have any notes for any potential corrections. Thank you. Now, Mr. Dunham, allocution, sir.
Thank you. Your Honor, the defendant, as the court is aware, pled guilty to 2 counts of aggravated CSAM and 1 count of using a computer to commit a crime. Recommendation is as indicated, credit for 132 days. Significant prior history involving minor victims. This incident involved late last year, the law enforcement receiving a tip that there were from a internet provider that there were CSAM downloads involving young children, bestiality, and infants. There was a search of the defendant's home. He was cooperative. His phone was seized and the CSAM was confirmed. The defendant himself was identified. The defendant did acknowledge he did enter the plea in this case. We believe that the recommendation is appropriate, and we would respectfully request that the court follow the recommendation.
Mr. Champion.
Your Honor, this is an unfortunate situation. Mr. Shepard, as the prosecution stated, has accepted responsibility. He understands this is an issue that he needs counseling with, and with that, we leave the rest of the discretion of the court.
Thank you very much. All right, Mr. Shepard, you have the right to make a statement. Is there anything you wish to say at all today, sir?
No, sir.
Great, thank you very much. All right, well, what the attorneys have said really covers it well. One might think and say, well, they didn't say a whole lot, but they hit the highlights. There are some convictions here that involve young people here and past. We also see a theft case involving a larceny in a building. And we see some prior criminal sexual conduct convictions back in 1998, 2001. Hold on. Oh. 2002, another criminal sexual conduct in the 3rd degree. Sorry for my pause. I was just looking to make sure that there wasn't any status of events changes that we need, but I can see why they're not listed. But anyways, now we had also a CSC 3rd degree in 2000, or a couple in 2004. So quite clearly there is an issue, as mentioned by the counsel, involving the defendant's activities with young people. Here is basically just possession of child sexually abusive material, which we basically know as being child pornography here. And the court, while recognizing that the guideline is 87 to 145 as a minimum, the court is limited, as acknowledged inside the report, by the 2/3 rule, which is actually a statute handed down by the legislature. Therefore, the court, not needing to find any substantial compelling reasons to deviate from the guidelines, but actually to say, I'm not allowed to go any higher than the sentence the court will give. For counts 1 and 2, the court sentences the defendant to 80 to 120 months. Again, that is below the guidelines, but it's actually not when you consider the limitations placed on the court by law. As to count 3, which is the use of the computer, the court sentences the defendant to, and I'm just going to go 48 to 120 months. That is within the guidelines. It's right in the middle. And these convictions will run concurrent with one another. Have I missed anything? Oh, wait. $3 $68 state minimum fees, Tina. One $130 crime victim right fund fee. I'm not going to assess any other full costs, attorney fees, or fines, as collection would be most likely ineffective. Have I missed anything, Ms. Odell?
Your Honor, did you mention jail credit?
Oh, 132 days, right? Yeah, 132 days, Tina, for each one of those 3 offenses. I apologize. Thank you, Ms. Odell. Ms. Odell, anything further?
No, Your Honor, thank you.
Mr. Denham.
In the same count for both aggravated possession of police and, Your Honor, just for clarification. The same sentence for both.
Yes, counts 1 and 2 have the same sentence of 80 to 120 with 132 days of credit.
Thank you.
And count 3 using the computer is 48 to 120 with 132 days of credit. Now, Mr. Shepard, what you are receiving from the defense counsel, Mr. Champion, is 2 copies of one document. You are to place your initials on the first copy. Doing so neither elects nor waives any rights. It merely acknowledges your receipt of that copy of the other copy. This document tells you that you have the right to appeal the conviction and sentence in your case. That's typically done by filing a claim of right to appeal. However, based upon the plea in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of that document and return to the court within 42 days. All right, Mr. Shepard, the way you've handled this case, pretty upfront, and I appreciate that. These are not victimless crimes because somewhere out there's a young person whose images were taken. But I think it's a fair and appropriate sentence, plus it's according to the law. Anything else, Mr. Champion?
No, Your Honor. Thank you.
All right. Thank you. We're adjourned. Our next case this morning is People in the State of Michigan versus Andrew Young. The case number here is 36-3672 FH. Looks like he'll be coming over from the jail. In the meantime, let's go ahead and take appearances, please.
Thank you very much, Your Honor. Attorney Robert Ration, Assistant Prosecutor from Stockton County.
Robert Hertzell for the defense. My client will be joining us shortly.
All right, thank you. That's any of this. At the table next to defense counsel. Also before the court is Mr. Luke Blazak, agent from the Department of Instructions, who is the author of the pre-sentence investigation report. We're here today for a sentencing in this case involving a conviction, 2, assault resist destructive police officer, operative while intoxicated 2nd, and domestic violence 1st. Mr. Ringson, did the defense, I'm sorry, does the prosecution have any amendments, corrections, objections to make to the contents of this report?
We do, Your Honor. CFJ 284, page 5.
Okay, I am there.
The second paragraph, it says MSP Labs confirm the presence of 0.012 of gram of alcohol. That should be 0.138.
0.138. Any objection to that, Mr. Hartel?
No objection, Your Honor.
All right, that will go ahead and be made. Anything else, Mr. Ringstrom?
No, Your Honor.
Thank you. Mr. Hartel, any amendments, corrections, objections to make to the content of this report?
None, Your Honor.
Great, thank you. Allocution, Mr. Ringstrom, we'll go ahead and start with you today.
Your Honor, the defendant did cause big disruption that day. He wanted to get into the vehicle after drinking driving. According to him, he purposefully crashed into a tree. He did not follow officers' directions and then tried to get out of the vehicle and did get out of the vehicle afterwards. And he could have posed a risk to the entire society as a whole with his actions. He got a, in my opinion, very good plea bargain based off of the idea that we did not charge him taking the vehicle or personally crashing the vehicle. That in a large part had to do with the victim not wanting any of those charges being brought or anything like that. We are asking for the $100 restitution to the sheriff's department that we normally do. My understanding is there is no other restitution that is being requested.
Thank you. Mr. Hartel.
Thank you, Your Honor. Due to this case being no contest, I won't allocate about certain aspects of it. I'll encourage my client, based on my prior conversations, to most likely not make a statement about that part as well, though I would encourage him, if he wishes to make statements about his life moving forward, his plans. I know he was more than willing to talk to our office social worker, who I do thank for submitting the mitigation report.
And I did read through that and I made several notes throughout the report.
Thank you, Your Honor. Without getting too much in detail on the record, because I know it's on YouTube, my client is aware of his mental health aspects and that I'll just phrase it, self-medication is not the best way to go when you're dealing with, really for anyone, but especially when you have mental health. He's been to Pine Rest, places like that. And I'll just leave it at that because I know the court can see where he submitted. But I would ask the court to consider going on the low end of the guidelines, releasing him with time served and probation. I did have a chance to look over the victim's impact statement that people did. Let me take a look at that before it was submitted to the court. I won't go into too much about what I read because I don't believe that's my place, but I do believe that it's appropriate for the court to factor that in as well. And if she wishes to make a statement, that's entirely up to her. But again, I do believe this is one where we're focusing on treatment is appropriate. Perhaps as terms of the probation require him to go to inpatient treatment. He has expressed a desire to do so. I know our staff has worked with him. They didn't quite get him to a location. Obviously, he's not in the Zoom from there, but he expressed with me as of late last week a desire to do so. And if the court wanted to make that a term of probation, he'd do it. If the court wanted to make it a term of his probation to comply with mental health, he has every desire to do that anyways. We realize it's not just one thing, it's an entire lifestyle, and addictions and mental health are both things that are going to haunt him for the rest of his life. With the right support structure, I don't doubt he can make it. I ask the court to give him the opportunity to prove that he can. Thank you.
Thank you. All right. Mr. Young, you have the right to make a statement before I issue a sentence. Is there anything you wish to say?
If I was to be released today, I plan on getting a hold of my psychiatrist and going to her office for substance use counseling. So,
Okay. All right. All right. Well, this is a difficult situation. The law says the court is to use probation where it thinks that the defendant is entitled to probation. However, if probation does not appear that it's going to work, the court need not give it, which of course contradicts with some other language provided by the legislature about how we are to begin with the presumption of probation, fines and costs, and no jail. But I tie those two together and say, well, If I don't think the defendant's going to be successful, why do I put him on probation? In this instance, I'm going to tell you, there are things that I'm very troubled by. And I don't know how to take this into consideration. I'll just explain it. When I look at CFJ 284 and I look at page, toward the end, 1 second, page 13. If I have a defendant who has significant mental health problems, why don't I see anything written in that section? Now, I do know that I have a report from the health or social worker who works with the public defender's office, which I do appreciate. It gives me a great deal of insight. But the defendant has significant mental health problems and apparently isn't getting treatment. And he's not getting it on his own. So why do I consider releasing the defendant who says, I plan on getting treatment, when he hasn't been doing a very good job at that on his own? And Mr. Blazak, I know the answer to my question, so it's kind of rhetorical. Is it easy getting somebody into mental health treatment? No. So the problem here is whenever somebody looks at me and tells me, well, Judge, we have a problem with mental health in the state, that is absolutely correct. Division of powers means I, as a part of the judiciary, I don't create them. I don't create mental health treatment. I'm not the one who determines, no judge determines how much funding goes into that program. Right? The prosecutor's office is a separate branch of the executive branch within the county. The Michigan Department of Corrections works for the governor, and they're the ones who also manage jails and the treatment programs. And the legislature decides how to fund them. Well, unfortunately, we don't have that. So I don't know what to do. I've got a defendant who has mental health problems who isn't getting his own treatment. He's been in and out of rehab, and that hasn't worked. He hasn't continued to take his treatment, apparently, while recognized. Now, there are other things here. I like to go through these, and I think I go through them with a pretty fine-tooth comb. The defendant doesn't work, right? Because he's on a disability, which he started in 2008. But he was still able to get a diploma in 2011. I don't know why he's not working. Well, maybe he's not working because he's been using drugs and alcohol since the age of 10. And he's 33 years of age. That certainly isn't going to help his mental health. Probably has contributed to it while his brain was in the period of development. When I read these, and I understand why they put in there, but like when I read these mitigation reports, we can talk, and it's okay to put these in. It explains how he got to where he's at. He had a really rough childhood. Now, he's got disability because somehow he's got 5 children, ranging from 10 months to 9 years of age, and he can't work, even though he's got a diploma. And even though he can afford, with whatever he does receive, alcohol, which he's been using since age 10, marijuana, which he's been using since the age of 10, and apparently doesn't use it anymore, but did use methamphetamine for a couple of years back in 2014 through 2017. So I understand he's had a difficult childhood. So what's the question? How does that apply to a judge? Is it given to me just to strike sympathy? Or is it an explanation? Either way, I can't do anything about that. I can't fix the past. Only the defendant can fix the past. And so far, he's not doing a very good job at it. I can't make him do it. And the legislature and the executive branch don't give us enough opportunities. The only opportunities they give me are coming through Mr. Blazak. It's not that it's not his choice. I mean, he's only got so many tools in his kit bag. They don't work for me. I don't work for them. If they don't give me an option, I can't put you into what you want. Just can't do it. There's only one place I know they have all that treatment. I look here at the event, and it was pretty difficult. The defendant was drunk and sped away in a car with a high rate of speed, throwing gravel all over the place. And when he was ordered to, by the police officers about what to do, he said, "Come and make me. Come and get me. I don't give an F. Fill in your favorite word that begins with F and has 4 letters." Then when he was arrested to lock me up, he continued to say, "Yeah," because when they talked about the argument, me and the police officers with the defendant, "Yeah, because she got in my mother effing face." This was his mom. "I belong in a mental institution and don't need to be let out," he said. Then he said he blacked out when he asked about what happened. Fell to the ground. "No, I just blacked the F out," he said. Then when talking about the tree and the vehicle, I wrapped the bitch around the tree on purpose. I don't give 2 Fs anymore. And that kind of conduct continued throughout the entire process. Allegedly, he told the victim in the case, "I'm taking the vehicle because I pay for it." I don't know how you pay for it under less than $1,000 of disability. So you're not getting the treatment you want on your own, and you're violent, drunk, and you resist police officers, and you become quite uncontrollable. Criminal history began as a juvenile with some disorderly jostling, although it started as something more serious. Marijuana as an adult began in 2013, and he had a couple cases that were dismissed here. But in 2016, there's where we see a trespass and assault and battery, which suggests some more, violence. Then in 2017, you're into methamphetamine and drugs, and you violate probation. In fact, you were sentenced on October 19th of 2017, and you violated probation by November 27th. Now, it wasn't a big deal, but you were already back to using marijuana and failing to comply with your terms and conditions. Well, when you were released from that case in October 2018, you made it about 8 months before getting picked up on some more charges. Now, these weren't big ones, but this operating when out in license means deception. Plus, it makes me wonder where you're getting a car. I wonder if you were paying for that one. I don't have any information, but I'll say that it at least applies to the deception. Then, while you were looks like while he was on probation, Mr. Blazak, you see that in CFJ 284, continuing from page 8 onto page 9.
Yes.
Yeah, looks like he would have been on probation for that number 7 of 10. So you violated probation with the same offense. Again, it's only drivable license suspended, but that sends to this court a message of deception. In fact, and that continues when we see 2022, but drinking and driving reduced down to an impaired, but also because I can tell he had no license before, he still had driving without his license. Then he violated probation. His probation was terminated. And October 11th, 2023, that was only 6 months after being off of probation. And now he's back to committing some more acts of violence. Therefore, he can't control himself and he beats up on people. And that was domestic violence. Then we get to our case here. And we're barely, not almost 2 years after being discharged from his probation last time. And now we're back to more of the same. He drives a vehicle without a license that apparently he pays for. So he has a vehicle without a license. We don't understand that one. And he's obnoxious. So what does this court do? I've got 2 intermediate sanction cells here. Sorry, 1, and then I got 2 misdemeanors. The law says for an intermediate sanction cell, the court is to begin with the presumption of probation, fines, and costs unless it finds reasonable grounds. Well, based upon repetitive acts of violence and drunkenness, inability to control his own mental health needs, as well as his prior probation violations, the court's quite confident that a jail sentence is appropriate here. That's for the R&O. Thus, for that offense, the court sentences the defendant to, I'm going to put him on a period of probation for 24 months. The court's going to adopt the terms and conditions for probation that are listed on CFJ 145, pages 2 and 3, find those to be well suited for rehabilitative purposes. The court assesses a $68 state minimum fee, $130 crime victims' right fund fee. Now, Tina, there are going to be some other fees for the other charges. I'll cover all those in just a second. As for the R&O, again, this is a intermediate sanction cell, but this defendant needs to understand to quit acting with violence. The court therefore sentences the defendant to 180 days and gives the defendant 94 days of credit. As to count 2, operate while intoxicated, or as a second offender, the court sentences the defendant to the 180 days with 94 days of credit. And again, he's on probation for that offense as well. The court then adds a $50 state minimum fee. The court also adds a $300 court cost, a $500 fine, a $300 attorney fee for the processing of this case. Of course, there's a supervision fee of $30 a month or $60 a month if there's any electronic monitoring. Also for that charge, the court assesses a $100 restitution payable to the Missaukee County Sheriff Department for emergency responses. All right, now, as to the domestic violence, count 3. Well, violence seems to be a pattern, and the court's not limited to that presumption. And, well, he's already served the 94 days, so the most I can give the defendant is by law, 93 days with 94 days of credit. And Tina, the probation only applies to counts 1 and 2, doesn't apply to count 3. And again, there's a $50 state minimum fee there. So I'm going to repeat that. 24 months of probation for count 1 and count 2. They're both 180 days to 94 days with 94 days of credit. And for count 3, it's 93 days with 94 days of credit. $68 state minimum fee, 2 $50 state minimum fees, 1 $130 crime victims' right fund fee, a $300 court cost, a $300 attorney fee, and a $500 fine, plus supervision fees of $30 a month or $60 a month if there's any electronic monitoring, and $100 payable restitution to the Missaukee County Sheriff Department. Have I missed anything, Mr. Blazer?
Thank you, sir. I think you.
Well, it's unfortunate. Sometimes it just doesn't make sense. There is no treatment programming, but I really wish there were. Somebody pick up a phone and go call your legislator. That's not within this court's discretion. I can't order something that's not there. All right. Mr. Hartel is going to bring you 2 copies of 1 document. You're going to place your initials on 1 copy and do so neither elects nor waives any rights. This document tells you that you have the right to appeal the conviction and sentences in this case. Based upon the plea in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of that document and return to court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. I hope when you get out, they're able to get you some kind of treatment. You have the right to be considered for release from your probation early at halftime if you're successful. All fines and costs are due within 56 days or a 20% penalty will be added. That 20% penalty will be forgiven as long as you're making payments before the end of your period of probation ends. It's up to you to get your treatment. Don't come here and ask for me to give you something that you could have already taken care of. Thank you. We are adjourned. Our next file is people of the state of Michigan versus Jessica Bailey. There are actually 3 files in this instance. And they are 23-3447, 448, 3450, FH. Appearance, please.
Thank you very much, Robert. Next, Jesus, Prosecutor, Peacock County.
Robert Hertz up for Mr. Bailey, who I believe is in the Zoom, although we can't see his face, Your Honor.
There he is. All right. Mr. Bailey now appears via Zoom. Mr. Bailey, are you able to see and hear this court?
Yes, I am.
We're here today for a probation violation informal hearing. Looks like the court was last on the record back maybe on the 29th of this month. And 29th of June. And we conducted an arraignment. There was no cause. The matter was set for a probation violation informal hearing, and the defendant requested counsel. What do we do? I'll say also before the court and the Department of Corrections, serving as a probation officer on this file. What are we doing today, Mr. Hartel?
Your Honor, based on my discussions with my client late last week and the people in the probation department today, I believe we may have a resolution, but I haven't been able to formally communicate it to him. I don't know if I could do a quick breakout room.
Sure, we do a quick breakout room. And right now we are at 10:10. This matter was set for 10 o'clock, but we have time. Mr. Bailey, Mr. Hartel is stepping out of the room. He's going to dial into the Zoom, and Tina will put the 2 of you into a separate breakout room. All right, and then nobody can hear see what goes on in that conversation. Thank you. We are in recess. Expected pleas in our final pre-trials today, gentlemen.
There's one on this headline.
We're good.
You would fail.
Just for the record, the payment plan is.
Ready? That's all on you. That's.
City Judge, I do want to make sure the record offered the defendant time served on a misdemeanor, and I want to make sure that's rejected before we go forward.
Okay.
Just want to make sure it's on the record before we do this. Okay.
Go ahead. This is Daniel LeBlanc, 24 CR 520.
Your Honor,
The state is present and the defendant is present with his attorney, Mr. Kindler. Go ahead.
I related an offer to the defense of time served for a misdemeanor conviction, and I understand that's been rejected. If that's been rejected, that's fine. I just want to make sure I give him one last chance before I do this.
Just to make sure the right terrorist listed here.
Terrorist,
Uh, she can't. You just give mom.
Oh, it's rather large.
Certainly, yes. He's indicted for a 3rd-degree felony, right?
yes, sir.
Okay. Okay. That carries with it up to 10 years in prison, but he's eligible for probation if he was found guilty.
You don't want to get out and burn up and stick that. No,
He's been pleading not guilty, so.
What's what I'm saying?
Yeah, and Judge, with that, I withdraw all offers after that. So we're not. Let's try it.
Okay, everybody hears that. Okay, then that will be a ready here. Jason Altman. John West.
Madam Judge, I'm ready for trial 6.
I'm sorry.
I'll try 24-608.
That's a possession.
He's habitual, so.
All right, Darren Patterson, Mr. Burbank.
What's passage right here, though?
What do you want to do? You're ready?
We're ready, Judge. I only represent him on the gun charge.
Yeah.
Trying to get him, but I am number one.
Who said you were number one? Who said you were number one? Was that a vote that was taken?
That was a vote.
Was that people had sent in letters and?
Oh,
John didn't want. John says he didn't vote.
I think I need to sit down on this one.
Which one do you represent him on? I don't know.
He's not joking.
What's the? I haven't told her the gun charges. Is there priors or anything? No, there are.
I didn't hear what you said, Judge.
Are there priors on that? In that indictment? What for?
I'm saying.
How many? One has to be amounts. I don't know if it's what she said.
Yes, sir, just one.
So it's a third degree enhanced to a second? And he's not eligible for probation, I guess. With the prior shit.
He votes for you there. She was
And he knows that. Okay.
And if everything falls through, Judge, I'll be ready on that.
Okay. There's going to be some others that are going to be ahead of y'all, but I want to set it briefly forward, just not far in advance.
Whatever date you need then.
It's 4 weeks good
Yes,
for
sir.
everybody. Okay, let's set this, try to get this tried on in 4 weeks. Okay. And it's the possession of a firearm charge that the state's going to go.
Yes, sir.
Okay.
Judge, can we find out who represents him then on the possession of a controlled substance? Or is he planning on?
I'll turn on.
Oh,
What do you say?
he's not represented on the possession of a controlled substance. He's supposed to be hiring Burbank, but he has not hired him on that other charge.
He might have come to a meeting of mine.
It's 2 years old. It's about time you hired somebody, but that's okay with you. We're going to move forward without it. If you don't have a lawyer, you can represent yourself. You've had more than enough time to hire somebody, sir. We're going to move forward in 4 weeks trying this thing. Okay, the special Aaron Traylor, John.
Yes, you're ready. You should talk about it quite a bit. Yeah.
Colby, Washington.
Yeah, it's been or not.
Yes, sir.
They're going to announce it. I was seeing that.
When are you going to be able to try it?
They have about 6 weeks. I've got to take care of it.
You see here.
Was Clark? I saw him in the hallway. He is. I can grab him.
Colby, Washington. No answer in the courtroom.
I don't mind giving Charles some time, Judge.
Okay. What are we going to do on Patrick Winston?
Judge, I'm hired on that case and I'll.
Okay, hold on.
I just want to, and he's here. My mouth is about it. He's sitting up all with some sunglasses.
Well, he needs to be in here. Where is he?
I'll come to the door in just a second. I saw him.
Should we have a musical introduction?
You see if I think so. Maybe that's quite in your.
Come on up. This is where the action is, sir. You got to be in the courtroom. You're Aaron. You're Colby, Washington. Correct? You have to speak up. And yeah, this is the way it works. We don't use sign language. You're charged with several serious crimes here, but let's get sit here. Understood which one we're going to be going on, okay? Because you got four. And we're going to reset this, but we're going to set it for a specific time and it'll be tried on that day. Yes, sir. And then we'll go to the next one and the next one after that. 1713 is second assault on child is second degree felony.
These all arise out of the same fact and circumstances, so I will likely try them conjunctively, Judge.
That is just based on discussion and discussions are going.
Okay, so there are 3 second-degree felonies which carry each one up to 20 years in prison, and then a third-degree felony and 1716. That's 10 years. So you're looking at a total of potential exposure of 70 years in prison, up to 70 years in prison on all this. And y'all are going on the sexual assault child?
I'll probably go on all at the same time, Judge.
I understand.
I will file a motion to consolidate and to stack the sentences if it happens.
Same complainant?
Yes, sir.
Yes, sir.
Okay.
As I said, we have ongoing discussions about it.
Can discuss all day long. We're trying the case.
Yes, sir.
And what's this? We're going to set it on a particular day from today. What's good? Give me how many weeks? Is 6 going to be good? 6. Okay. Set it specially set 6 weeks. And the relationship of the child to this person is
no relationship.
Because you can't have any contact with that person, nor anyone on your behalf. Let me speak. You can speak afterwards. She can't take when both people are speaking. She can't take it. Although she can do great things, but that's impossible to do when more than one person speaking at one time. And she has to, by law, take down everything that's said. Anyway, it would be inappropriate. Plus, it would be catastrophic to your bond, either through both your bond, if you find out you or someone on your behalf are trying to influence her or to communicate with her prior to this class. Understand? You know what that? Sitting there, waiting. That's it, Winston. What are we doing there?
He's here.
Okay, what are we gonna do, like,
Just so.
are you gonna try this or?
But I didn't plan on, he's right there.
Is he handling the case now?
I believe so.
Okay, you've hired him?
Yes, sir.
Okay.
Well.
Okay.
Yes, sir.
Then you're on it. Okay, 500 days old. What are we doing today?
Yeah, I was hoping you, it's not, I'll make my stuff.
There are going to be others tried before today, but we need something settled so that you're ready. Then we'll move forward on these types of cases. We don't want to delay anything longer than necessary. And how about we'll especially set it for is 6 weeks good? Perfect. We'll see where we are.
That's cool.
Latanya Bryant, get a resetting. Latanya Bryant, that's yours.
Judge, I can you just you said.
What are you doing on this song?
Judge, on Latanya Bryant, as I was prepping that case last week, I had a chance to talk. I had it with Mr. Ham as well.
How'd that go?
Right.
Was that?
No, that's fine.
Was that a good thing?
That's productive.
Productive. But Judge,
Pointed I wasn't there.
oh, hey, no problem.
Fun to watch. But we want to do.
Let me tell you what I want to do.
Yeah.
What happened was in
Mr. Men, and we have Mr. View from the prosecutor's office. We're here today for a pretrial, but it's my understanding Mr. Harris is going to enter a plea of guilty to one count, failure to comply with the order of single police officer, and we're going to set this for sentencing. Is that accurately stated?
Yes, sir.
All right. Mr. Harris, how old are you?
31.
How far did you go in school?
Some college.
Are you able to read and write English?
Yes, sir.
Are you under the influence of drugs or alcohol?
No, sir.
Are you taking any medications?
No, sir.
Are you a United States citizen?
Yes, sir.
We've had some discussions about your case. If you enter a plea of guilty to this charge, I'm not going to sentence you today because I don't know enough about you and I don't know enough about this case yet. What I'm going to do is conduct a level 2 pre-sentence investigation, also an evaluation to determine whether or not you're appropriate for a community-based corrections facility. And I'm going to set this for sentencing in about 6 weeks. I've told Mr. Madden generally what I do in these types of cases, which I impose a prison sentence and favorably consider you for judicial release. But I don't have my mind made up, and every case is different. I don't send everybody to prison for this kind of stuff. But to be fair, I send most people to prison for this kind of stuff. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
I have a document entitled Change of Plea and Entry. On the second page is a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Mr. Madden before you signed it?
Yes, sir.
Are you satisfied with the representation that you've received in the case?
Yes, sir.
You're going to enter a plea of guilty to one count of failure to comply with the order of single police officers, third-degree felony, punishable by up to 60 months in prison and a $10,000 fine. It does carry with it a license suspension of anywhere from 3 years to life. And if you serve your entire prison sentence, you're also subject to a mandatory period of post-release control from anywhere from 1 to 3 years. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at that trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, sir.
Mr. View, what are the facts?
Your Honor, if the case were to proceed to trial, the state would produce evidence beyond a reasonable doubt that on May the 14th of 2026 in the city of Franklin, Warren County, state of Ohio, and then pursuing the defendant on into Montgomery County as continuing course of criminal conduct. Franklin police officers responded after Middleton Police Department had terminated a pursuit of the defendant's vehicle. They located him within the city of Franklin, observed him to run a red light, activated their overhead lights and sirens in an attempt to stop him. The defendant fled at a high rate of speed at over 120 miles per hour into the city of Miamisburg, where he struck 2 vehicles, crashed his vehicle. There was a female passenger in the vehicle with him at the time. He then fled on foot and was located nearby and arrested. The defendant did indicate that he was sorry for running and he had messed up.
Anything on those facts, Mr. Madden?
Yes, sir.
Mr. Harris, did you hear those facts?
Yes, sir.
Do you admit that they are true?
Yes, sir.
Do you understand the right you're giving up by entering a plea?
Yes, sir.
Is this what you want to do?
Yes, sir.
What's your plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you have made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. I'm not going to go into the matter of the sentence today. I'm going to order a level 2 PSI, also a CBCF evaluation. Anything else for today?
No, Your Honor. Thank you.
All right, we'll see you back here in about 6 weeks. Next is the case of the state of Saman Rasaras. Am I pronouncing that right? Case number 26CR43640. Present before the court is Mr. Rasaras, represented by Mr. Madden, and we have Mr. Harris from the prosecutor's office. We are here today for a pretrial, but it's my understanding the defendant is going to go forward with a plea of guilty to the F4 improper handling and to the specification. Is that accurately stated?
Yeah, also the underlying offenses, Your Honor.
Yes, also the misdemeanors. Is that correctly stated, Mr. Madden?
Yes, Your Honor.
Mr. Rathrath, how old are you?
I'm 31 years old.
How far did you go in school?
Some college, Your Honor.
Are you able to read and write English?
Yes,
Are you under the influence of drugs or alcohol?
No, Your Honor.
Are you taking any medications?
No, Your Honor.
Are you a United States citizen?
Yes, Your Honor.
We've had some discussions about your case. If you enter a plea of guilty to this charge, I told Mr. Ben that I'm inclined to impose the minimum sentence, which is 6 months in prison. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, Your Honor.
I have a document entitled Change of Plea and Entry. On the second page is a signature above the line defendant. Is that your signature?
Yes, Your Honor.
Did you review this with Mr. Madden before you signed it?
Yes, Your Honor.
Are you satisfied with the representation that you've received in the case?
Yes, Your Honor.
You're going to enter a plea of guilty to 1 count of improper handling of a firearm in a motor vehicle. It's a 4-degree felony, punishable by up to 18 months in prison and a $5,000 fine. The maximum penalty also includes an optional period of post-release control of up to 2 years. We have a specification for the forfeiture of the weapon in the case. Also, we have resisting arrest and obstructing official business. Those are each second-degree misdemeanors, punishable by up to 90 days in jail. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. They have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to these charges, you're going to waive all of those rights. I'm going to admit that you did it, and we're going to get on to the matter of the sentence. Is that what you want to do?
Yes, Your Honor. I just would like to make a statement.
Okay. Well, is the statement about your plea, or is it about what the sentence should be?
It's about my plea, Your Honor.
Okay. What do you want to tell me?
Your Honor, in September 5th, I was just out of the hospital, 15 days. I spent 15 days in the hospital. I got in the hospital on July 30th due to hit by a car accident. I got hit by a semi, and I had to learn how to walk, and I was in medication and all that. They fly me to the hospital. I was in 86th Street, St. Vincent Hospital in Indianapolis. When I left the hospital, Your Honor, I was like in medication. I had to learn how to walk. That's why I wasn't driving my vehicle at the time. That's why the gun was in my car, because we were in process of moving. We were moving to Kentucky. We actually got a resident in Kentucky. My wife did. And we were in process of moving. The gun was in my car before my accident. And in the time, like when that all happened, I didn't even know the gun isn't there. It was out of my mind, Your Honor, like that the gun isn't there. I just wanted to keep it away from the kids. I have kids at home. I have 3 kids. I didn't want them to be, I didn't want the gun to be reachable. And that's why the gun was there. Other than that, Your Honor, I wasn't even driving my vehicle. I can't bend my knee or anything. And I had to be on a therapy, physician and all that. So my cousin was driving even the vehicle at that time when I got arrested, when the police stopped my vehicle. I didn't I'm not aware that the gun is in the back seat or anything. I just have it there, locked in the car. We have other vehicle that we drive around. That's why the gun was there. And again, Your Honor, I was at the hospital. I got in wreck for 15 days. I have document for that and everything. I was between life and death. I have to be aircrafted to the hospital. I am apologizing for the gun, being improper and all that. I'm not very intelligent about the law and how it works. However, Your Honor, I had this gun for 9 years. I have never been involved in anything with that gun whatsoever, threaten myself or others or harm it or even use it. I have never attempted to use it, not even for a sport or anything. I just had it for a fact that I had a business before, a restaurant, and we got robbed. And after we got robbed, I had the gun just to be protected, to protect ourselves and there. And thankfully, we have never used it. I lost my business in COVID, and that's the story for the gun. Other than that, I would have never even have a gun. I'm not even concerned about having a gun or anything. I'm not a gun person or anything. At the resistant arrest, Your Honor, the police was like I can say the same. Like they were like not being treating me well. Like it was like a lot going on with ICE and all that. I have to tell them that I'm a U.S. citizen. Their response to me was like, "Oh, we all are." I'm not resisting arrest or anything like they're saying in the document that I just read like 5 minutes ago from entering here. Other than that, I have never seen this report in my life. They're saying that I like they want to tell me order and I'm refusing to attempt to their order. I can't even walk and I'm in canes. And I've been even thankful for one of them who was helping me leaning on him while walking to the police car. And if this was on body camera or anything, you will see all of that. I have not even negotiated any one of them, like nothing. Like, am I being arrested? Yes, get off of the car. Okay, I have a surgery. Like, this is what we telling them. And this is what we saying, like, I resist. I didn't resist no arrest, Your Honor. I was in cane. When I went to the county jail, I was crawling on walls. And I have like to do all my physician by myself without like any help from hospital or anything. I have lost 80 pounds, more than 80 pounds. I'm at 191, just entering the county jail on the 1st of this month, Your Honor. And I got locked up on December 5th, a year ago, at the weight of 280 something. I had to put myself on a diet. I have to fast a lot. I had to exercise and to get myself where I'm at today. However, Your Honor, like, I'm very sorry for the action. I'm very sorry for anyone who been affected by my action. All what I'm asking you, Your Honor, is that it's been a year. I have 2 months left in prison. I'm really I lost a lot, and I don't want to lose whatever left for me out there. Like I have a wife and kids. And I have a job too that waiting for me when I get out. Like I don't want to lose the opportunity for that with spending more time in prison. Other than that, Your Honor, again, I'm just I'm not a violent person like this describe me or anything. It's just like the fact I'm not aware of the law. And I've been a victim myself. I know I'm not sure. I know this paper not describing me as one, but I am, Your Honor. I'm there's a lot of lies between all these charges, between all these years.
So, Mr. Estes, let me ask you this. I mean, you want to go forward with the plea today, right?
Yes, Your Honor.
We have a couple options for sentencing. If you don't want to go forward with sentencing today and you would rather I do a pre-sentence investigation, I can bring you back in about 6 or 8 weeks and we can do a pre-sentence investigation and I could look at this case for maybe placing you on probation. Based upon what I know now, I represented to Mr. Batten that I would give you the minimum sentence that I can give you, which deals with your current prison sentence. That would be 6 months concurrent to the time that you're already doing. If you want me to look at a pre-sentence investigation, I could do that, but that has both upsides and downsides to you. The upside for you is I might learn something about you that leads me to conclude that I may want to put you into my community control program on probation. The downside to you, though, is I might learn something about you or something about this case that makes me want to impose a sentence that is greater than the 6-month concurrent sentence that we talked about today. So if you don't want to go forward with sentencing today and want a pre-sentence investigation, we can come back. It's not going to bother me one way or another.
Your Honor, the thing is right here, I've been max for a F5 that I heard, and I met a lot of people, inmates in prison and in the jail county and all that. I've been max for F5, Your Honor. Even though I did apologize for my action in the jail county and all of that. And this is my first felony, and I've been max to it. All because when a victim show up and she got pleaded. But
again, Mr. Rasmus, I'm not saying what you're telling me is not true. Okay, it might be true. I can't control what happens from some other judge in some other county. All I can tell you is what I'm going to do in this case, which is if you want me to look at a pre-sentence investigation, I will do that. If you don't, we can go forward with sentence today. Do you understand your options?
I understand it, Honor, but I'm gonna go with the plea. Is because it's just from this experience. I've been max with it. I had to make my statement because more about who I am or what I've been going through.
Okay. Mr. Harris, what are the facts in this case?
Your Honor, if this matter had proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment, that on or about September 5th of 2025 in the city of Mason, Warren County, Ohio, the defendant, Samed Ross, possessed a firearm in a motor vehicle which he could not otherwise legally possess due to a protection order out of the state of Kentucky. Also, he failed to refuse to exit the vehicle and continued arguing with officers.
Anything on those facts, Mr. Madden?
No, the concern I have has to do with the obstruction. He's basically denied that aspect of not complying with the police officer, but Mr. Harris said it was arguing with him. And maybe that fits the facts pattern because he was trying to tell him that he was injured and could not get out easily. Is that what we're talking about?
Yes, Your Honor. I'm on canes, Your Honor. I have my whole leg have to be cut open. I stuck on a vehicle upside down for 15 minutes. The fire department start cutting everything in every angle, and at the end I have to be pushed and dragged, and that's what had my whole leg to be cut open. That's why.
Well, as I represented to Mr. Madden, and I know you weren't here for that when we were talking about this case in my office, I am not really concerned with the obstruction or the resisting. My issue is with the gun. So if you're going to plead guilty to the gun charge, I'm not imposing any additional sentence as a result of the obstruction and the resisting. Do you understand that?
Yes, Your Honor, and okay. I'm willing to plead for the gun because it's a foolishness. I'm sorry, English is my
You're doing fine.
It's my fault. It's my foolishness or for not knowing about more about the law about this matter. As for the protection order, Your Honor, it's been for 4 years before the event or something like that. I'm not sure, Your Honor, but it's been for years before. I'm married to another woman and I have kids with it. This is 4 years. I have never interfered with my ex or nothing. I have no intention to do any of that. The gun was in the car before even I got on the wreck. I wasn't driving that car. I wasn't even to drive the car. I spent 15 days in the hospital. And when that happened, it's just just the facts. It is I'm not denying it. It's my fault. That's why I'm pleading for it.
Okay, so you do want to go forward with the plea today, Mr. Rasras?
For the gun, yes, Your Honor, because it's my fault for forgetting about it or whatever it is. However, it's kind of my fault. But I have no intention to harm anyone. I have never harmed anyone with it. I have it for years, for 9 years. I have never even used it, Your Honor.
You acknowledge the protection order said that you were supposed to turn it over, right?
No, Your Honor. That's another thing, Your Honor. This is something I discovered after I got in the jail county and all that. Nobody told me to turn my gun in, nothing. I remember literally the judge, when he ordered for the protection order, he told me, you are not allowed to use your firearm for 3 years. I remember this very correctly, Your Honor. And if there's a record, and this should be a public record, this should be stated in my.
Mr. Rasras, I'm fine to have Mr. Madden investigate this further and get the transcripts or get the copy of the protection order. I'm going forward on the record that I have now. If you want to go forward today and enter a plea of guilty and accept the 6 months concurrent to the time that you're doing, I'm good to do that. If you don't want to do that, we can set this over for a trial. We can set it over for another pretrial, have Mr. Madden do some more work on it. Whatever you want to do. What is it that you want to do, Mr. Rasras?
I'm just, Your Honor, I'm just got sentenced for a max for a first felony. So I'm really concerned. I'm really worried. I want to be with my wife and with my kids. I already missed all holidays with them, Christmas, 4th of July, everything. And now I'm about to miss it again. After I was have only 2 months in prison. I not even have a ticket in prison. I'm I follow the rules and everything. if I resist arrest outside, I would like at least have an issue or prison or anything. I'm cooperative with everyone. I've been holding a job in the Joe County, and I hold a job in CRC, and now I hold a job in prison. I follow orders. I'm not into anything. Alcohol and drugs are against my religion and against my moral. I have never abused drugs or alcohol in my life.
So, Mr. Rasras, do you want to go forward with the plea today?
Yes, Your Honor, I'm not going to risk it.
Do you understand the rights that you're giving up by entering a plea of guilty?
Yes, Your Honor.
What is your plea?
I plead guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you've made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. Mr. Rasras, you do want to go forward with sentence today, right?
Yes, Your Honor.
All right. Mr. Harris, anything from the state?
Your Honor, we had requested, as we do normally when a person is incarcerated 6 months consecutive to the time he is currently serving, we would see no reason to deviate from that. He has 0 days of jail time credit. We would ask the gun be forfeited and destroyed.
Mr. Madden?
I think I can do as well as my client has just done, Your Honor, so we're fine, move on.
Anything else you want to tell me, Mr. Rasras?
Just a word with my lawyer before. Can I speak to my lawyer?
Sure.
Same thing. Yes, Joe is still there.
Thank you.
Thank you, Your Honor.
Anything else you want to tell me, Mr. Rasras?
Thank you for listening to me, Your Honor. Thank you.
All right, the court is going to impose a 6-month prison term. This is going to be concurrent, which means at the same time as the sentence that you are already doing. We have 0 days of jail time credit, and I'm not going to impose a fine. I am going to impose the costs upon you. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer, to obtain a transcript, or to pay the costs, they'll all be provided to you at no charge. Good luck to you, sir.
What weapon did you mention?
Yes, forfeit and destroy the firearm. All right, we are in recess.
With me visiting with her and preparing for this trial.
Yes.
And I did communicate with Mr. Ham. She was hearing voices, and the voices wasn't me. So out of abundance of caution, I filed a motion to have her listed for competency because and this was last week when I was talking to her. The voices started coming to her, and like I said, it wasn't me talking to her. So I got kind of nervous about that. So I wanted to.
Did you hear the voices?
No, I didn't hear them. And to my understanding,
had to be asked.
Well, hey, and to my understanding, she does have a history of mental illness.
Well, you need to look into that and
yes.
get that. But yeah, something firm so we can make a ruling on it and whether it's competent or not.
But I did file requesting to have Dr. Rapon at least look at it.
Yeah, I'm printing it out. Just a second.
Are you retained on this one?
Well, sir. Next one.
Let's see.
I think she's got some prior convictions of aggravated assault and delivery of a controlled substance. Is that?
Yes, sir. And I also understand from talking with Mr. Ham, and another reason I want to reset it as well, in addition to getting her tested, is that I understand that there's another case that's supposed to be coming that's going to be indicted, I guess, soon. I don't know the details of all of that because they don't talk to you about that. But
They were filed.
but I do understand there's another case that's coming down the pipe.
4 wasn't enough.
No, we wanted more. There's one more coming, Judge.
Let's see.
It's actually scheduled to go before the grand jury this week.
We got 4 felonies, separate felonies within a span of 3 months.
Yes, sir.
And I think that
Where is she now? In Cutting? Okay.
And just formally, Judge, the state is ready to move forward on the aggravated assault with a deadly weapon, clause number 25 DCCR 0885.
Okay. Okay. Hey, Langston, your motions for an examination regarding insanity. We need to put something on the record other than just a summary. The issue has been raised. What is it about it that you can articulate that we can put in the record?
Yes,
because this is just a summary, and everybody would file motions if it was just this succinct. Because what's a problem here, among other things, is we've got this cocaine charge that comes along after all of these. You have 4 separate events here on separate dates in just a matter of months: an aggravated assault with a deadly weapon, and 885 with 2 prior second-degree felony convictions. So that second-degree felony, the first-degree felony punishment, then 25-10, evading arrest and detention, third-degree felony with the 2 priors alleged. So that becomes a second-degree punishment. Then illegal possession of controlled substances, state jail felony with those 2 priors in sequence. So that becomes state jail felony punished as a second degree. Call up repeat. And what do you miss? The collision, third degree punished as a second. So And what bothers me is this was just 4 different serious felonies within just a span of about 4 months. Anyway, if you can articulate and get this to me, and then we'll work on that. Getting back to the pond, and then but we're going to foresee and set it in 2 months. Okay, a trial in 2 months.
Okay.
Is that going to be good for everybody here? Yes, sir. Thanks. So here's the motion. All right. All right, Langston. Renuka Holiday, please. Who is on that? Renuka Holiday? That's a Simmons.
My understanding is she had told me this was going to be reset based upon a vacation letter.
It says this case is reset until July 6th, and then that's today. That's what I had. Where's your attorney? You're mumbling. I don't understand what you just said. Speak English, please. What did you say? Where is your attorney?
I have no idea, sir.
Okay, what is your attorney's name?
Glamore?
Galmore, I believe you say.
Galmore?
Oh, Justin Galmore.
Judge.
This is
It's Haley Simmons, Judge.
Judge, she did file a vacation letter.
I thought Haley Simmons was your attorney.
Yes.
She is.
That's not what she just said. She just said Dustin Galmore.
She's in that firm, Judge. That may be the misunderstanding.
Okay.
But
there's some misunderstanding, but she ought to know who her lawyer is.
Yes, she should.
She did file a vacation letter for some reason. I missed that, Judge. That should have been said.
Till when? To when?
Her vacation is complete on the 12th.
What's the next date for that? The next trial date after that, we set it. Please. You gotta restage that lady. Adrian Booker, Langston.
I'm Judge. He's in custody, and if we reach it, I can get ready on that.
It's ready on proposal number.
Are all of yours, are all of yours trials?
The only one that's not, I didn't want to be a trial is that last one, Hakeem Richard. If you look at that, it's at the bottom, Judge. But more particularly, I needed some more time on that one because I had 3 other cases on the trial docket this week. But that's how Richard, I just wanted to reset on him. And he is here. He is all the way to the back next to the lady, the light and the lady on the wall. They right next to each other.
Adam Chavez.
Thanks, Judge.
Okay. Adam Chavez, John. Hello.
I can be ready on that. I got ready on the first 3 that I had. So
yeah, I'm just Dominic. I'm trying to ferret out what can be tried and what can be disposed of. Well, it's. I don't understand this. Everybody wants a trial out of these 40 cases. And as you know, we try more than anybody else in the country, but I can only try one at a time. Dominic Rubin?
Yes, I'm ready for this.
You ready?
Yes.
Kevin Peterson?
Judge, that one is a little more extensive. I'm not sure who the new prosecutor is going to be on it. If I could get.
Who is on it? On Kevin Peterson for state, please?
As you
It was assigned to Cal and she's gone. So
I understand.
I don't
She's got it.
Tommy, but I've put it on Tommy's radar that.
Where's he today? He's not around. He's clearing stuff out. It's clear.
yeah, he's trying. Well, he had one case left over that's specially set next door, so he's trying that.
How much time, y'all?
4 weeks.
4 weeks, fine.
Is 4?
Yeah.
Reset 4 weeks on Patterson. Hakeem, that's Langston again. Kendra Petrie.
That's where we said.
Well, I'm always ready, but there's a number of co-defendants.
We're going to reset that one.
Yes, sir. There's 2 co-defendants that I need to make sure she's set with.
How long?
I think they're set in September.
Is that what we want to do? Set this, I'm resetting this from July to September? Is that what we're doing?
Huh?
Is that
I
what
think that's when those are set for.
And Robert Chason, John.
Same announcement, Your Honor. I mean, I'm ready on the other ones. I mean,
All right. Okay.
I'll see if I can still work it out, but I don't, but it's not.
Yeah, I'm gonna either work it out early or we try it. And
Yeah.
that's, but they can sit around and their life goes by. Here's what we're going to do is, Mr. Ham, Lakey, are you ready on that to go?
Yes, sir.
One. And Parker, two, John?
Yes, sir.
And LeBlanc is three. And Altman is four, I think. And then finally, trailer, five. I think that's all we can do. And then let me get these two pleas on Clark and Edmondson, okay? Langston and Marvin Lewis.
I think he's next door.
Not surprised. Here is all of this. Thank you. Sorry, couldn't get much done. Marvin, we're ready on a plea on this is Edmondson, right?
No, Judge, I went over there to finalize it with him. He wanted to speak with the court. I believe he wants new counsel.
No.
So
You didn't get new, not today. Good Lord, 1,000 days? Where is he?
he's in custody. He's in custody.
Yeah, give me his file. Please.
Hey, Judge, yes, I'm here. But the other one on, I was just telling him, listen. That's that first case, right? Well, what's that? You didn't get the, yeah, there's one. It's just pulling this one out. Hey, quick question for you, Judge, on Foreman. That's this case. The Leslie Court Foreman. I gave him the offer, which is 10 years. I know he's a habitual. I just wanted one reset to make him back. That's the first case you called. You just called the jail run. On that case, if you don't mind, the offer is 10. He's habitual, looking at 25 to life. I just wanted to have just one reset to think about it. And I think he's going to end up taking it. But I don't want to put it on my trial doc. And I did give him his discovery on this too. So, but the offer is 10. And
Where is he? He's back there?
He's in the back.
Yeah, we'll bring him out in a minute, okay?
That's cool. But I just wanted to give him a little time.
Okay. We'll get Foreman out for still a minute, but I need Javon Clark.
Clark, we already did the plea.
Was it plea? I'm sorry, it's
Judge, are you sure you don't have Edmondson right next to you?
maybe
It's not this stuff.
Clark, there's Jordan. And then Marvin Lewis on Edmondson. We needed him out.
Yeah.
Come on out. Jordan Edmondson, please. We're working on it. Who was the other guy we needed?
For Langston?
Yeah, Langston.
Yeah, mine is that Foreman, or whatever. Yeah, I'm not there.
Yeah, let's bring.
Oh, yeah.
You want Foreman first?
Yeah, Langston, your guy's Foreman?
Yes, sir.
Okay, yeah.
He's here.
Let's talk.
Foreman file. It's on the regular document.
Today is the 6th. You said you do sometime. Yeah. Actually, it's on the lot, sorry.
All right, we're called 26 CR 293, the state of Texas versus Leslie Kurt Foreman. You're Mr. Foreman?
So
And you were here with Mr. Adams, your attorney and the state's attorney. I'm looking at this file here. And this is an indictment charging you with failing to comply with sex offender registration, which you've only been convicted 4 or 5 other times of that. So you know that it's got ramifications. It's got requirements because you've been convicted failing to register in 2004 out of Faulkner County, Arkansas. Failing to register out of Faulkner County, Arkansas in 2009. After that 2009 conviction was final, you committed the offense, it says, of failing to register and were convicted of that felony in 2011. After that was final, you were convicted of failing to comply with sex offender registration for life and were convicted of that in 2020 out of Bowie County. You've been an habitual felon at least three convictions ago. So you're looking at 25 to life. You understand? Yes, all right. That's just so you know. And this is what this alleges is, once again, you're accused of failing to comply with sex offender registration in this county. And so you're not eligible for probation, and your minimum sentence is 25 years to life. Do you understand all of that? Yes, all right. So what else? Did you want to put something else on the record?
yeah,
Go ahead.
yeah, just often the case is 10 years. He is aware that he's habitual, looking at 25 to life. He did not want to place the case on the trial docket. I think that he needed a little bit more time to digest the offer and just wanted one more announcement, but he did not want to reject the plea offer, and he did not want to set it on the trial docket. I think he had some affairs that he needed to get in order. So that's what he was asking for. But I did.
Well, he doesn't work on his timetable. I mean, this thing's been indicted since February 16th.
I didn't know what the.
It's going for 5. It's 5 months old right now.
How about start 2 weeks then? Just 2.
I got 1.
1 is perfect. We can we'll take that. 1 will be fine.
All right, you've had more than enough time to think about it.
Thank you, sir.
You had 1 week.
Thank you, Judge. Appreciate you.
Thank you.
I'll live in.
Hey.
I'm talking with Miss Moore on one of hers, trying to figure out if that one's gonna be dismissed or not, and then what the direction of the others will be.
Okay,
If we could have 2 weeks on that.
you got 2 weeks. All right. And ma'am, your name, please.
Crystal Bass.
Your Crystal Bass. Okay, you've got 2 cases, Ms. Bass. In 25 CR 1809 and 1810. Assault on hospital personnel and hospital property. Each of these cases on or about, well, one was alleging on or about November 8th, 2025, that event. And the other is on or about October 14th, 2025. And then the indictment, God bless you, goes on to allege that in 2019, you were convicted out of Hardin County District Court for attempted aggravated assault. So these 2 charges on assault on hospital personnel are 3rd-degree felonies. If all of this was found true in these indictments, your punishment range is a 2nd-degree felony. You're looking at no less than 2, no more than 20 years confinement in prison. Probation is not an option because you have, according to the indictment, been previously convicted of a felony, which eliminates any probation. Look at this. And she had earlier been evaluated by Dr. Ed Griffin for the issue of competency to stand trial. And Dr. Griffin, in a letter dated June 26th of this year, a week or so ago, deemed the defendant to be competent to stand trial. In this evaluation, which the court is going to mark as court's exhibit 1. This day, in each of these cases.
Every single one of them is an evaluation.
I don't have enough room behind. We're going to use 2 exhibit stickers. Okay, now this is court's exhibit 1 in for each of these cases. Part of the record and sealed it for purposes of related issues that may come up during the trial. What are we doing?
Judge, I just wanted to go over her options with her. She has a current offer from Tom Coleman, the new prosecutor in her case. That was only good for today. He's offering a plea for 2 years, running concurrently on each case. After today, that offer will go up to 5 years. As you explained to her, you do have 2 pending 3rd-degree felonies. You understand that, right?
You have to speak out so she
And then with that prior that you have on the record, you understand that he wouldn't be eligible for any kind of probation out of trial. Okay, and with that prior that you have on your record as well, that would also enhance you to a higher punishment range. So instead of your punishment range at trial being the 3rd-degree felony range of 2 to 10, it would enhance to 2 to 20. You understand that? You understand that you have a current offer on the table for 2 years TDC, and then you have 140 days credit.
Yes, ma'am.
Okay, and are you wanting to accept that offer, or do you want to set your case for trial?
I'll accept the offer.
Okay,
Is this a plea in each case?
yes.
To run concurrently? Right. That you understand?
Is that what you want to do? You can set your case for trial.
Write it up.
I just need to make sure that you understand all of your options.
Write it up. That's good today.
Okay.
Thank you. Thank you. We'll get to this here. Did you say Burkett as a bond hearing? Yeah, we're gonna get to that.
Sure, that's fine.
Moves other stuff.
Here.
We'll get to that later though. Yeah. Bridget West.
She's a plea judge.
No. Okay, that looks like this. Right, Bridget Wedlow. You're all ready?
Yes, Judge.
Bridget Wedlow, it's on page 4. Kendall, thank you. You're doing a good job, by the way. We lost our other bailiff for, who had been there for 100 years.
They didn't lose them. He were declared.
He retired.
They're some great friends.
So you don't feel like he's a loss to us, huh?
We will feel
I see.
but
Okay, I understand what you're trying to say.
for him in his retirement.
Well,
She's jealous.
kind of said if it weren't for you, he'd have stayed. That's what he inferred.
We worked together for 15 years. He put a
I know.
long time ago, those to me.
He called that a living hell. By the way, is the way he described that.
We get statue. Graduation week for me.
Congratulations. She's like top lady in court coordinator. In this profession, she's got a special degree, and also her final that she had to prepare is being published on bringing live coverage, YouTube, the case court TV to people. And because of the efforts Lacey did, she got a special honorary award for that. She graduated first in her class. Yeah, smart lady.
Just raise your right hand.
And I think we're in Miss Dennis. Nice guy. He was with me for the whole time.
Really?
20 years. Yeah. I guess he just got tired of me, really.
Yeah, it's not you, Lacey. You knew it was his time.
When we were in high school, he went to Beaumont French. Coordinates his ropes. I ran track, but he threw the shot and the discus, the state records for those 2 events. He was a famous guy, because he was big. He was the size he is now when he was in high school, and he was strong, man. Yeah, nicest guy. Yeah, we're gonna miss him. All right, I need a file here on Bridget. You're Bridget Redmond?
Yes.
26 CR 133 is called the State of Texas versus Bridget Wedlow. That is you. Present with Ms. Manaldi, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? And we proceed in summary.
Yes, sir.
In summary, this indictment alleges that on or about December 2nd, 2024 in Jefferson County, Texas, you committed 3rd-degree felony of having a prohibited substance in a correctional facility, namely marijuana. You brought into the jail, Jefferson County Jail. You understand what you're charged with.
Yes.
Now, this is a third-degree felony, which carries with it up to 10 years confinement in prison. And an agreement has been pleading guilty to the lesser included offense of illegal possession of marijuana, a Class B misdemeanor. Just want to make sure, is this going to work under this indictment?
I believe.
I don't know.
But that-
No, the indictment says intentionally and knowingly take a controlled substance, namely marijuana, into the jail. Is that going to be covered under illegal possession of marijuana under the elements? That's all I want to know. I don't know.
I mean,
The allegation, we're doing a lesser included from intentionally and knowingly take a controlled substance, namely marijuana, into the Jefferson County facility. I mean, that is going to match up with illegal possession of marijuana, which are the elements that we're looking at. I don't know. I don't think I've ever done a lesser included like this. But it might have. What do y'all think?
I'm not sure if it's going to fit, Judge. This is,
Yeah.
Mr. Coleman did this. I'm just not sure it's going to fit. Who was? No.
he thinks it is. I think he's smart.
See, it's under the Controlled Substances Act, isn't it? So
It's under, well, 3811 is what it's under. Prohibited substances in I was a correctional facility. This says G. But there's a way they could have alleged it where they possessed it while they were in the jail. That would have been, that would have worked. This is
The
tape.
tapes is-
Don't.
Well,
3811C is tapes.
that's 3811B, isn't it?
B is for alcohol, Judge. C is for controlled substances.
Now, it says takes alcoholic beverage, controlled substance, or dangerous drug into a correctional facility is subpart B.
Then C is controlled substance and also a dangerous drug.
Into property owned, used, or controlled. Prohibits a person provides or possesses with intent to provide. Okay, let's see.
I don't know if we can move that and take it and say possess, but no, because that's a whole different section. But taking would be, you'd have to possess it to take it.
That's my argument.
Point, Your Honor. I'm the one that created this situation, Judge. I apologize. My breath. I was upstairs working on the trial. So I took the stairs down. Judge, if you don't believe it is, I was watching on YouTube. If you don't believe it's a true lesser included, I would suggest that we do an oral amendment.
No, I question it. It's just.
I was.
We don't want to pay for the same real estate twice.
Sure.
So.
Well, could we do an oral amendment to the indictment, Judge?
See, this one is a bar exam question because the indictment alleges a crime under 3811. The person commits an offense if the person provides or possesses with intent to provide, C, subpart C. A person commits an offense if the person takes a controlled substance on property owned, used, or controlled by a correctional facility, and into
What's that?
and I would think into the facility is on property owned, used, or controlled.
Judge,
So,
just my 2 cents on that, coming from a C- lawyer. I would just say that to take something into,
who are you talking to? Which one of the lawyers are you talking about now?
Myself.
Oh, wow.
To take a controlled substance into a facility necessarily implies that you possessed it to take it, Judge. Well, I think we can cure.
But it's under subpart B under section 3811, and you're stating section 3811G.
I think we can cure any questions, Judge, if we just do an oral amendment. If the defense counsel is not opposed to us doing an oral amendment to the indictment, and I think we can cure also.
So now we've got either tampering with witness or something else.
Yeah.
Fingers in my ears.
Why not? I think that could work.
We're fine with that, Judge. It's the same resolution
And-
to us, for us regardless.
What you're doing is, it's, you're bumping it to a misdemeanor that
Whatever, however,
the DA's office, the executive branch of government would be controlling, not the grand jury. And this is word for word a crime under person under subpart B under section 3811. A person commits an offense if the person takes a controlled substance into a correctional facility. And that's what it's alleging, word for word, and that's subpart B under section 3811. And this indictment is captioned section 3811 subpart G, which is just the offense.
Well, the caption, as the court's aware, it's not substantive.
It's obvious what the grand jury intended, that it fall under that statute. And
we'd like to just orally amend the indictment, Judge, to possessing, as opposed to taking, possessing in a correctional facility, or just strike the rest of that correctional facility altogether and just possessing marijuana, and then strike the rest of that marijuana, Judge. To intentionally, knowingly possess a controlled substance, namely marijuana, and just strike the rest of that, Judge. And I don't think the defense counsel would be opposed to having any objection to that.
and then that would be the same result of getting to the lesser included.
And anything above the quote unquote line, as far as the caption, is not controlled, Judge. As far as the statute that's cited above the lines in the indictment.
But, okay, so then what you're doing now is going under the Controlled Substances Act, not under the penal codes.
Yes, sir.
So now just, statute is word for word under that section that was indicted is word for word under subpart B, which ought to be enough. I mean, it's the same statute to be proper lesser included.
How are the court seats to
However you prefer, Judge. Either way, she's not having included to the indictment. It's still the lesser included.
Yes, sir.
Okay, we're going to change this to 3811 subpart B.
Yes, sir.
Without objection?
Correct. From the state, Judge.
Small case piece.
You already grabbed it. I don't know.
And then this is a class A misdemeanor, everybody? Oh, class B misdemeanor.
The intent was the B. Yes, yes, sir.
Well, the problem is there isn't a class B misdemeanor under that statute, under that section. So we're not, it's not or lesser included under there. I think what y'all need to do is file information on it, on a class B under the Controlled Substances Act. Because I think it's a landmine waiting to be, I mean, y'all aren't going to do anything, but somebody later on, somebody could challenge it. I think it's an issue.
Even with an oral amendment to track the statute under Controlled Substance Act, Judge.
Well, you're now going under a charging instrument from you're not working off the indictment from the grand jury. If there was something under this indictment that we could do, but it's.
Oh, one other thing, Judge, and I don't mean to be the dead horse. We'll let this go after this, after I make this pitch to the court. What if we do the 3811? Was it B that you were thinking? And because it does not.
Yeah, that's right. But there is not.
But there's no misdemeanor there. But what if we did an attempted under that one? Would that get us to a misdemeanor?
It just
That would get us to a state jail.
Okay.
30 degrees.
And then with state jail, could we punish it as a misdemeanor, Judge?
You can use
That would give.
44B if you want to.
Yeah, I'm just trying to move the case. Judge. I'm all about moving cases.
That's 44B, county, give this week.
Yeah.
See, we're working on 3811 and 31. It doesn't fit.
Yes, sir.
Just the punishment range that the statute sets forth is too high.
We can do an information, Judge. I just.
We're just trying to do it.
Yeah, she's got 132. She's got 132 days jail credit, and under the facts, under the circumstances,
What we can do,
it is not.
could you get an information done today, and then we'll bring it tomorrow morning, and then.
I don't know the answer to that.
I know you're busy, but we could bring her just as soon as an information is ready.
Yes, sir. This is not the kind of crime of the century, judges.
I know, but it's still, we're dotting the i's, crossing the
Yes,
t's. It's still important.
It is.
And it's misdemeanors have their place.
Yes, sir.
According to the legislature. But the quicker you can get it done, we can come in and, so she doesn't have to. That's. And it's for time served, right?
Yes, sir.
Is that what y'all are trying to do? Get her
We're
out?
trying to. She's got 132 days jail credit, Judge, and under circumstances, I think she's. I think this justice.
Here's what's her bond right now? Oh. Let's just, we gotta get it done just right under the, crossing the i's, crossing the t's, dotting the i's, which may take more than a couple of days. Okay. Where's your home, ma'am? Where's your home?
I stay in Houston.
All right, if I can give you a personal recognizance bond so she can be released, any objection to that?
No, Judge.
You're gonna have to report. If you fail to report, the deals are off. We're gonna have to report back here for a plea. And we're gonna set it for, you need to be back up here, because I'm gonna release you on a personal recognizance bond, so you don't have to post a bond anymore. But you have to report back. Can we get this done in 2 or 3 days?
Yes, Judge.
I'm here Thursday, so we can.
Set it for Thursday. On the docket, you have to be here by order of this court at 9 o'clock, okay? And we're gonna give you,
The other misdemeanors that I
I don't know what you're talking about now. I'm just talking about this case. That's all I know about. I don't know what you have otherwise. I'm talking about disposing of this case. And then you come in, you plead, time served, and then they would put you into I think they have to check you into the jail, and then you get released and you've done your time. But we would take care of this case. I don't know what your other cases are. That's not in my court. You've got to figure those out. I'm just talking about disposing of this one here.
if I stay incarcerated though, they'll call me out.
They'll bring you back Thursday if you stay, yeah.
Where we set this for Thursday at 9 o'clock. Then I'm going to set a personal recognizance if she can make it. If she can't, we'll, because of the other bonds that she has to, or the other holds, but we'll dispose of this case on Thursday. And you'll get time served, and then that will be finished, completed, and then you can not worry about this one. But be here on Thursday, one way or the other. Okay, if you're released, you have to be here at 9. If not, you'll be brought here at 9. Okay.
Thank you, Judge.
Thanks, you. Great. I just saw
Judge, did you?
now.
Did you want to see Mr. Edmondson with Mr. Lewis?
Okay, Marvin, come on up. What's next? What are we doing on this?
This is the one that we thought we had a plea worked out, but Ms. Edmondson has informed me that he wants to release me and his family hire a new attorney.
Okay. Where is it? Yeah. No way. You can hire, but here's what we're doing. It was this was set for trial. It's 1,000 days old. Sorry. And it's a murder case. We're not going to wait until the last minute and try to manipulate the court. This was set for a plea. That's fine. If you don't want to plead, plead. If you don't plead, that's okay. It's for trial. So we'll try this case first today. All right. That's
Judge, I was under the impression that it was going to be a plea. I need time to go and make sure my witnesses are available for today.
Yeah.
Okay.
That's not your fault. That's manipulating that I don't like. But there are no deals. We'll try this case first. Okay. That's what we will do. We'll set one. I think set number 1 at 1:30. Next is who else has a so Scott, come on up. We got you. Who is it?
Mr. Simpson. So bond.
Remember the
Judge. Was it Dusty? Obviously.
You what?
You didn't think of the voice?
Yeah. The house up there.
Real fat, so
What are we doing here, miss?
it's a motion to set bond.
He's on regular probation. You know that. All right, 23 CR 267 is called Aaron Simpson. That's you? Mr. Simpson?
Yes,
Okay. And Mr. Rennick is here representing you. You've been on probation for the third-degree felony of evading arrest or detention. You were sentenced to 10 years in prison, and that was suspended for 10 years on September 11th of 2024. A motion to revoke probation has been filed alleging nine violations, including driving while intoxicated at a location other than your residence after curfew requirement, failing to work faithfully, failing to report to the probation office, provided urine sample with tetracannabinol in your system more than once, and alcohol in your system, that's another violation, failing to enter and successfully complete defensive driving, and then failing to pay court assessed fees. So you're on regular probation. The law does not state that you're entitled to a bond on regular probation. So when there's a motion to revoke probation, so I'm going to follow that law. Have a hearing. I'll give it, when the state can be ready, we'll run it up here, but there's going to be a hearing. I'm not, under these circumstances, I'm not going to release him. Nope. You were convicted and you were supposed to follow the rules, and we got 9. It only takes 1 to get revoked, but we got 9 violations. When can the state be, Brandon?
Ready in 3 weeks, Judge.
Judge, I need to start a trial beginning of August. That would be in trial for a week.
We're going to do this before August.
Okay. So I can be ready by the end of the month. It's going to be tight for about desires.
Got to get it in 2 weeks. Gentlemen, 2 weeks?
Sure, why not? We're always up for a challenge.
That's it. That's the rule. That is all. All right.
There's no problem. What is that? Judge, Mr. Evans, to address the pool in regards to his concern for us. We can't do it. Time to hear counsel. So
what's his reason?
Well, he doesn't believe that I've been representing him to business.
All right. We'll bring it. He wants to come out again. All right. Bring him out. Or Edmondson. Give me that file with him. I got it. Try Edmondson again.
And she's upstairs gathering up her witnesses as we speak, so. Another Monday.
Come on out. We're back in 23 CR 2076 Jordan Edmondson. This has been set for trial. Thank you. Mr. Lewis has been in this for 2 years and then representing the defendant. And actually longer than 2.5 years. We said a bunch of times. I'm going to file numerous motions. It's where they created it. And back, and this is back in February, 6 months ago now. This case was set for a plea hearing in March. I don't know what happened on that. I guess it's not showing. I guess on March 9th, when it was set for a hearing, y'all decided it had to go to trial.
Yes.
I guess. All right. So it's been on the trial docket then since on or about March 9th. 4 months. And we're ready for trial. And it's a case which is it's almost 1,000 days old. And you've been on it for years. And I know Mr. Lewis prepares and does well at trials. And so, period. Now, you want to get somebody, you can represent yourself if you want, but we're trying this case at 1 o'clock. You can go hire somebody, but I'm sorry, y'all have been for years.
Give me 3 days?
No, years. You've had years, 2 years, over 2 years. So we're trying this case. Y'all wanted a trial. You got a trial. And then
in the same though.
You're going to interrupt. You just, the rules of the court. Who is that standing up? Sit down. You can't.
It's not his fault. The offer's not changing from our side. We're not changing the offer. It's staying the same.
It's been set for years, and we're going to try it. And it's a murder case, which is the most serious type of case. It moves. It becomes on the front of the line. That's the way the rules are. It's a most important type of case to trial, and we're not going to delay it. Y'all wanted a trial, you got what you want, and at the last moment, manipulating, you don't have the time we're not going to do that. He's a competent lawyer. We're going to try the case. You pick a jury at 1 o'clock, period. That's the way it is. If I open the door for one, everybody would come. I know it's been 3 years. Today I've decided I don't want a trial. And everybody gets ready, and then it's a trickery. It's a game of trickery and sleight of hand. It's manipulated. You don't get to decide when the trial is. You wanted a trial, you got it, and it's going to happen at 1 o'clock. Thank you. That's all. Lori Carozzo. I hadn't seen Lori.
I'd seen her this morning.
She's in another court. She'll be here. She's just running late.
Okay, Aaron Simpson on.
That was when you dealt with Judge.
On Scott on the bottom. Yeah. Mercy Bruno. Brent.
My understanding is from the Wichita Falls Behavioral Health Center, she's still incompetent and needs further treatment. They're asking for, I think, a year. We can extend it that long, but that's what the report, remember, from memory said that she's not all there.
Yeah, it's not to exceed 12 months. So.
And I don't have any issues with that. If she needs the help, she needs the help.
We already signed.
But I guess it's not what we have to have some sort of hearing. Unless you guys are going to have.
Oh, yeah, I'm hearing on that.
Well, anyway.
Extend for 12 months.
Okay, on this Mercy Bruno 25 CR 556 case, what concerns the court here is this current commitment expires on the 9th, July 9th, which is a couple of days. And that's why this was set for a hearing. The defendant is currently deemed incompetent from the Texas Health and Human Services Commission's findings that the court has a copy of that I know y'all have. And they are recommending that the defendant be recommitted to the facility that she is currently in, receiving treatment for a period not to exceed 12 months. That's what everybody wants.
Yes, sir.
Mr. Turk, on behalf of the defense, you didn't speak.
Judge, my understanding is she's incompetent, and I have to rely upon the medical or the behavioral health experts on what's best for my client. Her treatment, unless the code.
I have copies from the Texas Health and Human Services Commission, from the superintendent, Tim Beeman, Beaman, requesting recommitment or renewal of the defendant's commitment, which expires July 9th in 3 days, and that she be recommitted for treatment in the facility at the Wichita Falls State Hospital under the provisions of Article 46B of the Texas Code of Criminal Procedure for competency restoration for a period not to exceed 12 months. In the package that the court has received is a cover page from the administrative assistant for Wichita Falls State Hospital, which is a cover page, a physician's certificate of medical examination for mental illness consisting of 4 pages, signed by Dr. Mahona, Mohona, Sadhu, Sadhu, MD, at the Wichita Falls facility, which states that the defendant is diagnosed with schizoaffective disorder, neurocognitive disorder, hypertension, and vitamin D deficiency. And that treatment with psychoactive medication, group recreation therapy, and therapeutic. And I've never seen this word used, milieu, MILIEU, which is French. But this is the mental health treatment that this physician is recommending, which the court has seen in the past. And that the defendant is suffering severe and abnormal mental, emotional, or physical distress, experiencing substantial mental or physical deterioration of ability to function independently, which is exhibited by the patient's inability, except for reasons of indigence, to provide for basic needs, including food, clothing, health, or safety. And the defendant is unable to make a rational and informed decision as to whether or not to submit to treatment. And this is supported by an affidavit signed by Dr. Sadhu, Sadhu. There is a second physician's certificate of medical examination for mental illness, which is prepared and signed by Dr. Shelley Hafferkamp, Haferkamp. I'm not making these names up. at the Wichita Falls facility, which has similar findings as Dr. Sadhu's findings in Dr. Haferkamp's physician certificate for medical examination or illness, and her affidavit states that the defendant needs continued treatment. And the court also has trial competency evaluation report of just signed by psychologist or psychiatrist Kelsey Beers, BEERS, of the Wichita Falls State Hospital, which states that the defendant is presently incompetent to stand trial, and with continued treatment, the defendant may become restored to trial competency in the foreseeable future. As such, the following is recommended. 1, recommitment under Article 46B.102 of the Texas Code of Criminal Procedure. And 2, continued review of her psychiatric medications for optimal benefits. All of this is made a part of the findings that this court states that the defendant is deemed incompetent and will continue treatment as ordered by the court for a period not to exceed 12 months under the Texas Health and Human Services direction and control, and that the defendant shall continue treatment at Wichita Falls State Hospital or any other proper facility deemed appropriate by the Texas Health and Human Services Commission. And that will be all placed into written findings and an order in that case. Deshae Edwards.
Judge, we just got the videos for that. If we could get that reset.
For how long? You got 4 weeks for an announcement. Okay. Then John West.
Yes, Your Honor.
Chadston Bryson.
Please, Your Honor.
All right. I need Chadston Bryson, please. Chadston Bryson, please.
This is the one we had an MTRP hearing on last week, Judge.
Okay.
Previous settings spots. I know you remember that.
Yeah.
So we take care of the case along with it.
Does he need to go in front of you?
Yes, sir.
Mr. Bryant, go in front of that lady. She's going to swear you in. Thank you.
I'm here, sir.
We now call 26 CR 285, the state of Texas versus Chadston Wayne Bryson. That's you?
Yes.
With Mr. West, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here for the proceedings summary?
Yes, Your Honor. Please.
In summary, this indictment alleges, sir, that on or about January 13th, 2026, in Jefferson County, Texas, you committed the state jail felony of forgery of a United States savings bond. Do you understand what you're charged with?
Yes, ma'am.
If convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, Your Honor.
Agreement's been reached in your case, you would be pleading guilty and sentenced to 2 years in the state jail. That would run concurrently with 857. Is that a case I have, or is that already?
We disposed of that with the hearing on it. That was the sentence you gave the defendant
the other day.
Yeah, like last week, I believe.
And these cases would run, these sentences would run concurrent.
Yes.
Is that your understanding of the plan?
Yes, sure.
If I follow this, you have no right of appeal. Do you understand?
Yes, sure.
You got you can't make this stuff up. Look at that.
I know, I see it.
It's just working, you know? Yeah, it is. Well, but it's not erasing it, but that's okay.
Yeah.
Yeah. If I follow this agreement, which I intend to do, sir, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to the state jail felony? Guilty or not guilty? What are you saying?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. I show you what's marked as State's Exhibit 1. Did you sign that document, understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read through. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury and cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true. So help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, please.
I will follow this agreement, sir, if nothing further, and I'm going to find that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. There is sufficient evidence supporting your guilty plea from State's Exhibit 1.
Like the sentencing entry waived fees.
I agree. Mr. Spicer, is there anything you'd like to add?
As far as the expungement?
Yeah.
Just that prior to this, other than my juvenile record, I had never been in trouble. At the time, I was really unable to work due to a back surgery, and I just screwed up. That's the only trouble I've ever been in as an adult, and then never been in any trouble before or after this.
Well, let me ask you this, Mr. Spicer, because when I went back and reviewed this morning, I did note that you did not successfully complete community control. The court ended up having to unsuccessfully terminate you. So, I just kind of want to hear from you why that was and what changes you made after you were released from community control.
The main thing that kept me on probation so long was the inability to pay the fines.
You were never assessed the fines.
Yeah, I was told my probation was supposed to be 1 to 3 years, and I was on probation for almost 5 years due to not paying the fines.
Let me go back and look. Because I found you indigent at the time I sentenced you, so that means there should not have been any fines or costs assessed. That's why, even though this report says that there were financials owed, I'm going to ignore that because that's. Let me see what else I have on behalf of the.
That is what Jessica Rupp kept telling me is, pay something.
Well, but you were removed from ILC. Hang on, let me pull it up and I'll be able to be.
Your Honor, it looks like his first or a probation violation in 2018 was for positive drug screens and failing to report.
Do you remember that?
Yes, sir.
Okay, so again, again, let me pull my notes up so I can have a better as far as time and stuff.
That was the same nature of the violation in 2020. 2 was failing to report and positive drug screen.
So you see what my point is this, is that I mean, you tested positive, you ended up losing your ILC and being convicted of these charges. And then you had another, your ultimate violation, which led me to just let you serve out local time, was another positive test. It had nothing to do with the financials because my entry clearly says that I waived those. So I guess I'm just looking to you to try to explain that to me.
I honestly, that's what they were telling me, is that I have to pay something.
Do you not remember the positive drug screens?
Yes, I remember the probation violations. I remember all of that. It's just, but I was told that I did have to pay. You may have waived it at the end when you terminated my probation. I'm not sure, but.
And that's true. That's true. No, I waived it at the time. Well, let me, I'm still trying to pull this up. It's not wanting to cooperate. Just so that I'll just make sure that I remember correctly. All right, so you were placed on ILC on March the 12th of 2018, right?
Right.
There were 3 felony charges, B&E theft and possession of criminal tools, right?
Yes, sir. Yes, sir.
Okay. So then we go to so your first violation was March 5th of 2021. So you'd been on for 3 years. At that time, you tested positive for oxycodone, failed to report for an office visit.
That was his second violation, Your Honor. Look, I think there was one back in 2018, and he was continued on.
Oh, okay, you're right. I didn't go back far enough. Okay. Okay. Did you do a CBCF?
What's that?
Were you ordered to do a CBCF?
I'm not sure what that is.
Did you go to CCC or Monday?
I went to River City.
River City, okay. All right, so that was then you had a second ILC violation. And then on that time, that was in 2022, and that was for you failed to report again, positive for benzodiazepine. I terminated your ILC that day. And then I basically sentenced you to local time. At that time, you'd already served 238 days. You got an additional 60 days in the Warren County Jail. Sound right? Okay. But when I sentenced you on June the 14th of 2022, I found you indigent that day. So the ILC officer was correct, but that's not why you were continued on ILC. It was because it was prolonged because of the positive test. It had not. I'm telling you right now, our probation department does not hold somebody up from keeping them on supervision just to pay court costs. We don't do that. Now, had you continued and finished ILC, and we terminated you from ILC and dismissed the charges, and then you came in to seal it, you would have to pay the court costs. Then we might hold this up, but I do not hold up terminating ILC based on financials. You were on ILC because you kept testing positive for drugs.
Right.
Am I right?
Yes.
And then and ultimately that's why your community control was terminated.
That's just.
So again, that's where my question is why should I do this when you did not successfully complete community control? I get that's my question.
My strongest point is this is my only trouble, and it's just the reason it's so important for me to get this sealed is because my son just turned 16. I got him a car. He's got a job, but staying with my girlfriend and her grown son, he's in a bad environment. I'm trying to get into a different place. It's hard nobody will let me even apply with these felonies on my record, and I just need to get my son out of that environment. And it's, yeah, I can't do anything with these felonies on my record. And I've tried the best I can to stay out of trouble and be a good role model for my son. And he's doing really good. He got his temps. He started driving. He started his job last week, you know, not long after he turned 16. I'm just trying to get out of the place I'm in now and get my own place for me and my son.
Anything else, Ms. Nicholson?
No, Your Honor.
All right, the court will find that the required time period has passed since the defendant's discharge of his criminal case. There are no criminal proceedings currently pending against him. The offenses are eligible to be sealed. The applicant's interest in having these records sealed is not outweighed by any legitimate government need to maintain the records. I'm going to grant your request, Mr. Spicer. I just wanted to kind of hear your explanation as to why you did not successfully complete community control. So, all right, so I'm going to grant your request. If you'll give me 1 second, I'm going to file this document electronically. Okay, I've sealed it. Mr. Laux is going to hand you a copy of this entry. You need to hold on to that for your records. Okay, sir?
I
All right.
appreciate it. This
Yep,
helps me so much.
Okay, thank you.
Mr. Urban, if you want to step up to the podium. Make sure you get copies for your records if you need them.
This is Ms. Durbin, you say?
Yes.
All right, this is case number 24CR42269, the state of Ohio versus Amber Durbin. Ms. Durbin is before the court on her application to seal her record. There was a report of probation that was prepared. Has everyone had an opportunity to review that?
Yes, sure.
Have you reviewed that, Ms. Durbin?
Yes, sir.
You find that to be accurate? Any additions, corrections, or deletions?
No, that's correct. I know that they, Hamilton County, I have already sealed those, but I understand that you still have access, but those, yes.
I do.
Yes, those are accurate.
All right. Anything else you want to add?
That at the time when these issues were happening, my husband was a severe alcoholic and we had our issues. We're now in counseling and we're doing much better.
Okay.
And
All
he's
right.
not drinking now, 7 months.
That's always a good thing. All right. The court will find that the applicant's charges all right, the court will find that the defendant successfully completed intervention move conviction, and these charge was dismissed on March 20th of this year, 2026. Court further finds that there are no criminal proceedings currently pending against her. The charge is eligible to be sealed, and the applicant's interest in having the record sealed is not outweighed by any legitimate government need to maintain the records. I am going to grant your request. I'm going to file this entry right now electronically. Done. All right. Congratulations. Mr. Laux is going to hand you a copy for your records.
Thank you so much. You have a
Thank you.
great day.
Well done.